The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. Welcome, everybody, to the Fourth Circuit. We're happy to have you. We'll hear arguments in 23-7201, Mason versus Talley. Happy to hear from you to introduce our lawyers for the day.
Yes, good morning, Your Honor, and may it please the court. My name is Daniel Scott Harawa, and my job is easy today because I get to introduce recent NYU Law School graduates, J.D. Morales and Nick Field, who will be arguing under my supervision.
Thank you very much. Counsel, we're happy to hear from you.
Good morning, Your Honors. My name is J.D. Morales, and I'm appearing for Appellant Omari Mason this morning. I'd like to reserve 5 minutes for rebuttal. May it please the court. While Mr. Omari Mason was at Riverside Regional Jail facing federal criminal charges, defendants repeatedly violated his 14th Amendment rights against pretrial punishment. Twice, defendants shackled Mr. Mason to a
Sorry, can we just clear that up? Because that seems like a really critical question. Whether he was there pre-trial or post-conviction on his state charges, because that affects the standard we apply, right?
Yes, Your Honor.
I thought that your client he had written a letter to the court saying he was finishing up his state time, which is up on December 27th, 2022. So why doesn't that resolve it, that he had been convicted and was doing his state time?
Yes, Your Honor. So Mr. Mason did plead guilty to state charges. However, Mr. Mason repeatedly stated in his...
And that's July of 2021.
Yeah.
And before that time, he was put into the state prison system when? On this particular instance. Obviously, he'd been there a lot, but when did he first go in on this stint?
Yeah, so in this particular instance, and we're not entirely clear on this record why specifically, but on August 19th, 2020 is when he began his time in RRJ for the time period at issue here.
And at that point, he had not yet been indicted on federal charges.
Correct, Your Honor. That would not be until May 19th, 2021 is when.
And then in July, he pleads guilty and gets sentenced to effectively 1 year. Whatever it was, 20 with 19 suspended and 5 with 4 suspended.
Yes, but the key thing here, Your Honor, is that we don't know exactly. Mr. Mason had been in RRJ for some time, and we're not clear, and it's not clear on this record exactly how much of his sentence he had actually served, how much of his time in RRJ. He was in RRJ prior to August 19th.
But we understand, based on the federal detainer, that when his state sentence finished, he was then transferred to federal court. So we actually do know that, right? That's what a federal detainer does. And so when was he transferred to federal custody? Made his initial appearance when?
I believe he was transferred to...
March of 2022.
Yes.
Okay, and so he's in state custody until March of 2022. He then makes his initial appearance on federal charges. So help me understand why you think he wasn't in state custody serving a state sentence in, for example, December of 2021? Like what about that could possibly mean he's doing something other than serving a state court sentence? That is the sentence of 5 years with 4 suspended and 20 with 19 suspended or whatever it was?
Well, so, Your Honor, it's not clear on the record in front of us exactly how much time was credited towards it. It's entirely possible that he had finished serving that time by the time that at least some of...
But didn't he say he hadn't? I mean, there's this December 5th, 2022 letter where he says, I was in state custody, I went and spent some time with the U.S. Marshals, and now I'm back at RRJ finishing my state time, which is up on December 27th, 2022.
I'm so sorry, which,
That's JA 332.
okay. Well, so, so Mr. Mason, in other writings to the court, made it clear that he was, he explicitly said that he was not even yet convicted.
When did he make that statement?
So that was in response to.
No, but what was the date?
The date, Your Honor, is, 1 second. Apologies, Your Honor, 1 second.
While you're looking, and can you also tell us which conviction he's talking about there when he says he wasn't convicted? I mean, one of the challenges with somebody who has so many different charges pending against him, he had like quite a few different charges for which he might not yet have been convicted, right? He had the state charges that he got basically a year sentence on. He was charged with the contraband offense, which he was not ultimately convicted on, and then he had the federal charges, which he was not yet convicted on. So even if this statement that you have was useful, how would we know what conviction he's referring to? I mean, he's got a lot of convictions, right? And so to the extent there's any clarity from that, it seemed like to me Judge Rushing's answer provides like perfect clarity.
Well, so in that particular instance, he was referring to his pending federal criminal charges. And the other parts of his complaint also support this when we look at the fact that he's talking about not having access to the law library, not being able to participate in his own defense. That doesn't.
But why is that relevant to the question Judge Rushing has asked? Because the question Judge Rushing has asked is about when his state conviction happened and when his state time began and when he was serving his state conviction. So the fact that he wasn't yet convicted on the federal offense just doesn't matter.
Well, so, Your Honor, we don't know exactly when he finished serving the state sentence, but we do know that he was in RRJ facing federal criminal charges and that he was there pursuant to a federal detainer. The record in front of us, we can't say when that end date is based on the record in front of us. We have charging documents and we have a document that refers to some calculation of time applied, but there are times it doesn't say whether on the record in front of us, how the time is being calculated, how much of the sentence he was serving, whether
Is he challenging how the sentence was calculated?
No, he's.
I mean, he could say the state was wrong, but that would still place him in state custody. Even if the state was wrong, the state might have made a mistake. I don't know.
So
right? But he still was in state custody serving a sentence.
Well, so the issue is we don't know when he was completed serving his state sentence. We're not disputing the actual sentence itself.
Maybe when he said that he was finishing serving his state sentence, why wouldn't that be like a good place to start, right? His statement that I finished serving in December of 2022. That seems like a person with knowledge who's stating when he's finishing his state time.
Well, he's also. Well, so we don't know exactly when. Mr. Mason maintains throughout that he is there, that he is done serving his state time. But this only goes to resolving whether or not the 8th or the 14th Amendment standard applies. And under either standard, Mr. Mason's claims should have survived summary judgment. Under the 8th or 14th Amendment standard, the two incidents of shackling, Mr. Mason's claims were sufficient to have survived summary judgment. So twice, Mr. Mason was shackled for hours to a telephone. In the first instance, he was shackled for more than 6 hours, and he was there for so long that he was forced to urinate on himself and soak in it for hours. In the second instance, less than a week later, despite telling RRJ officials and defendants, please don't do that to me again, he was there for more than 4 hours. He was there for so long that he passed out and struck his head and injured his wrists because he was still shackled to the phone. And we don't know quite exactly how long he was there in either instance because defendants have failed to turn over video evidence that demonstrates just when he was returned to his cell. The Supreme Court made clear in Hope that shackling a person to a stationary object for an amount of time that exceeds that necessary to quell a threat or restore order violates the Constitution.
That was a hitching post, right?
Yes, Your Honor.
You know what a hitching post is?
I-
They described it in the opinion, right? The person's hands are shackled above their shoulders. It was intended to punish that man, right? He was out in the sun without a shirt. What was it, 7 hours?
Yes.
On a hitching post while they mocked him and didn't give him anything to drink despite his thirst. And so you're comparing that to having one handcuff on a telephone because he wanted to use the telephone. And if he didn't want to use the telephone, the policy was to shackle him anytime he's outside the cell, right? So he would have been shackled to a table or something.
Well, so the policy is that certain detainees or prisoners in RRJ are to be shackled for a recreation hour, and defendants have never once at the court below or here explained why Mr. Mason was there for more than 6 hours, for more than 4 hours. In the second instance, the only...
They have explained why he was shackled, because we can read through your client's, record and come to the reasonable conclusion that the state had pretty good reason to think that shackling him was a good idea. Maybe not to the phone for the whole time, but having him shackled doesn't seem like a wild and crazy idea here, given your client's actions, does it?
Well, so...
I mean, do you agree with that? Do you agree that the policy of having your client shackled is an eminently reasonable policy for the detention center to adopt, given the conduct that he engaged in throughout this time?
Well, the policy specifically mentioned...
Well, start with the question, and then you can explain something else if you'd like to, but do you agree that it was reasonable for the detention center to have a policy of shackling your client, given his conduct in custody?
Yes, Your Honor, to the extent that it's a 1 hour recreation shackling policy, which...
In Hope, there is some discussion about how he was shackled, but the discussion is about the amount of time that he was shackled and the amount of time that he wasn't given anything to drink or allowed to use the restroom. Am I correct?
Yes, Your Honor. In fact, the court in Hope specifically states that it is that while things like being outside are, potentially relevant, it is really at root being shackled to a stationary object for that period of time that surpasses that serves a legitimate penological purpose, and that much like in Hope, Mr. Mason was shackled to a telephone without any justification for why he needed to be there for more than 6 hours, and we don't know how long, without any, like Hope, water or bathroom access. Yes, sorry.
What is the injury that you're claiming? Right, the objective prong requires an injury or a substantial risk of an injury.
Yes, so Mr. Mason suffered several concrete injuries. He suffered permanent scarring and cuts to his wrists. He became so dehydrated that he passed out and struck his head. And he was forced to urinate on himself and soak in it. Additionally, Hope specific...
So the requirement is a serious or significant physical or emotional injury.
Yes.
So what's the evidence of that in the record?
Well, so defendants' own medical records provided showed that Mr. Mason was so dehydrated on the second instance that he was exhibiting clinical signs of dehydration, skin tenting, which occurs when someone is
And
severely
that's from
dehydrated.
4 hours indoors in a climate-controlled area without water.
Well, so again, Your Honor, we don't know exactly how long he was there, but for at least 4 hours. And it was enough that he passed out from dehydration such that he needed to be treated. He attests to the fact that he received injuries from the hours and hours of being shackled, of being restrained, cutting into his skin. and from passing out and striking his head. And Mr. Mason says he doesn't know how long he was unconscious on the floor. So Hope also specifically highlights that in this case, specifically that the plaintiff in that case suffered, that there was the high likelihood of risk of injury there, the exact kinds that Mr. Mason himself did in fact
And
experience.
in Hope, there's no dehydration, there's no passing out. And-
Exactly.
And the court still said that there's a significant risk of injury.
Yes, Your Honor, the risk alone was sufficient there. And here, Mr. Mason is actually saying that he suffered a head injury where he heard a sound in his head for months afterwards.
Can I ask, your time's almost up, it's just one more question. So, assume for just a second, hypothetically, that Hope does not clearly establish the right that you are seeking to establish. Would you have us look anywhere else? I mean, are there other, I understand your argument on Hope, and we could play that out a little bit more, but just assume for a minute that it does not specifically establish the right that you're trying to assert here. Do you have anything else that you would have us to look at to clearly establish the right?
Yes, Your Honor. Well, so under the 14th Amendment standard, we have
All right, maybe to make
Robles
the
versus-
hypothetical helpful, like, let's stay in the Eighth Amendment context, just because I'm trying to give you an opportunity to help me. So assume for a minute, hypothetically, that Hope doesn't get you there and that we're in the Eighth Amendment. What would you have me look at?
Yes, Your Honor. So we have
Maybe your counsel can answer that on reply.
yes.
Thank you, counsel, for your argument.
Thank you, Your Honors.
We're happy to hear from you, counsel.
Good morning, Your Honors. Brian Atari on behalf of the appellees. May it please the court. I wanted to start out just on some of the questions about what standard actually applies here. I think, Judge Rushing, your question hit the nail on the head of we have an admission by the plaintiff saying my state time ends in December of 2022, so almost more than a year after the events of this lawsuit. And I think below, it's important to note what his position actually was. It's this vague assertion that he hadn't been yet convicted of a crime, and also that he wasn't confined in a quote-unquote prison. As we know, that's not the standard of whether you're in something titled a prison or in something titled a jail. It's your conviction status. And at that time, he pleaded guilty to 3 criminal offenses on July 8th of 2021. He has a representation saying that he was still serving those sentences up until December of 2022. So below the argument wasn't, well, okay, I actually had pleaded guilty to these offenses or I had been convicted of these offenses. It's just that those I'd received time served or those were issued to serve concurrently, and so after a year I was fine. That wasn't his position below, and that wasn't the position in the opening brief. It changed in the reply brief to say, okay, yes, those convictions did exist in state court, but we just don't know and it's too obscure. I think his notice of change of address clarifies that point that the Eighth Amendment is the relevant standard here.
Can you tell us anything based on the way he was treated in federal court about whether he was serving a state sentence or not? Obviously, we know in May of 2021, the detainer says that he is not currently serving a state sentence. And then he shows up in March of 22 is when he makes his initial appearance. Would you have us draw anything from that time sequence as to when he was serving a state sentence and when he was not?
I think maybe what your Honor articulated earlier when speaking with the plaintiff, I think the more, cogent consideration is the fact that he is returning to state custody after entering the plea agreement in federal court. He's coming back to state custody to finish serving that, and then he returns to federal custody, and several of his filings in opposing the MSJs are from a federal penitentiary in South Carolina.
And did he, when he was returned, I think this is March of 22, he goes, makes an initial appearance, comes back. When he's returned, did he have any pending charges in the state system separate from the convictions on the 3 charges that you described?
Your Honor mentioned earlier the contraband charge. As far as that, that's all that I'm aware of, or I think.
Do you know whether, this is not a memory test, I'm not
Right.
trying to do that, I can look it up as easily as you can, but do we know whether that remained pending in March of '22?
I do not know at this moment, Your Honor. I think, though, that just it's clear that the position below was not in a quote-unquote prison, hadn't this vague assertion that he hadn't been convicted of his criminal offenses, and then what was in the record as far as the disposition notices go and the representation that he even understood himself to be serving state time when he was returning back to Riverside Regional from Pamunkey. That doesn't resolve the procedural due process. That's going to be under the 14th Amendment regardless, but I think it does apply obviously to the conditions of confinement claim that plaintiff has asserted. Moving to the procedural due process claim, unless this court would like me to move somewhere else first, the kind of two-part.
Your colleague focused on the Shackling claims, that seems like a
Certainly, Your
place
Honor.
to maybe start there rather than the other claim that your colleague chose not to address at all, probably for good reason, so maybe go to the Shackling.
Fair enough, Your Honor. So moving to the Shackling claim, and I would say that the condition, anyway, I'll move to the Shackling claim, Your Honor. So as far as both the objective and subjective element go, there has to be the subjective or the significant physical or emotional injury or substantial risk thereof. I don't think, and I think the court was very clear in Hope versus Pelser, they repeatedly noted that it was relevant to the facts of that case as plaintiff had presented it, the specific risk presented by the factual situation there. And you have an individual in the summer without a shirt on who had been offered water maybe once or twice and is shackled in a way such that his arms are above his head so that if he lets his arms drop, the handcuffs are cutting into his wrist, and otherwise he has to hold them up in a stress position to prevent that from happening. He's also getting mocked throughout that entire time. I think from a physical injury standpoint, that is not comparable to the factual circumstance here.
How is that, when here, this, Mr. Mason passed out from dehydration? You all aren't disputing that he was dehydrated, are you?
I think based on the record, that's his representation. That's what I think the district court accepted the fact that he was dehydrated. Our position is that there was no evidence that he did not have access to water before he left his cell. He never stated that. And when he received medical treatment, the medical record, I believe the injury is at 1 o'clock in the afternoon. And so.
But you don't dispute that he passed out? There's no dispute that he passed out?
No, Your Honor.
And I believe in the dehydration, he passed out. He had to be seen by medical staff at the detention center, is that correct?
Medical staff did come see him, Your Honor, yes.
All right. So how is that not significant risk of injury?
Because I think, Your Honor, he's, again, in a climate-controlled facility. People go without drinking water for 4 hours. Frequently, people do that when they are asleep. I don't know that there is a case or even just a situation that would put a correctional officer on notice that an individual not drinking water during a 4-hour period might result in them passing out due to dehydration.
But we don't know if he asked or if he didn't ask, because you all didn't turn over the second video in discovery as you were ordered to do.
It's not that it wasn't turned over, Your Honor. There was representation that it didn't exist. And so it's not like there's a lot of discussion about
You're also not arguing here, in this posture, you might if it ended up going back for discovery, but you're not arguing in this posture that we should do anything other than accept his representations about that 4-hour period.
No,
So,
no.
For our purposes, at this moment in time, we have to assume that he was not given water during those 4-hour periods.
Yes, Your
Right.
Honor. No,
Okay.
sorry. I apologize if any of that was unclear. No, Your Honor. My position was that I don't know that there is a situation or a case that I've seen where an individual, even if they requested water during a 4-hour period, that there is a significant risk that they are going to pass out from dehydration when there is no understanding that they didn't have access to water before that time. I think the Jones versus Solomon case that we cite in our response brief, which dealt with an individual who was in a dry cell, he was provided water once in an 11-hour period, and this court didn't discuss the fact that that could have put him at risk for dehydration. I think that separates this from Hope versus Pelzer, where you have an individual in the sun in the middle of the summer in Alabama without a shirt on, coming from a work site after he'd been just subdued by 4 officers, whereas here, plaintiff is in a climate-controlled environment. There's no allegation that he's not. There's no information or indication that he didn't have access to
But
water.
isn't that what your argument is exactly what Hope rejects? The 11th Circuit, the materiality of it doesn't have to be, I guess, one-on-one. Here, you have someone that's dehydrated, 6.5 hours, 4 to 6.5 hours shackled. It seems to me in Hope that the main tenets of that case is the discussion of how long he was shackled. Not how he was shackled, where he was shackled, 6.5 hours for a recreational, 1 hour recreational period.
The Hope, respectfully, Your Honor, I read it differently. I think it is very unique to the factual circumstance. I don't think it is just the duration of how he's restrained. If that is the bent that Your Honor is reading it with, I think it then is looking at the punitive aspect of it, of these individuals there's obviously one person there watching him
If
as
that's,
he's.
can I ask this, if that's true, if Hope just says you can't be shackled for 4 hours, that would mean you can't be shackled for 4 hours, whether they're giving you water, food, rest, bathroom, but they literally just can't keep you shackled for 4 hours? I mean, is that,
Well, I think Hope is shackled without minimal life necessities. That's the part he's missing, the minimal life necessities, and I believe water is a minimal life necessity.
I would agree, Your Honor, but I think going without it for 4 hours isn't putting an individual in a position of a significant physical or mental injury or substantial risk thereof. Again, people sleep.
so can I go back to, just to understand your position on that, minimal life necessities? Do you agree that you have to have water within a 4 hour period?
No, Your Honor.
You sort of answered that as like, that seems right. I just am making sure. I thought you were saying earlier that like having water every 4 hours is actually not a minimal life necessity, that lots of us, even though we probably should drink more water, don't drink water every 4 hours.
No, that is my position, Your Honor. Water, generally speaking, is a life necessity. I don't think having to drink water every 4 hours is required. And under the Eighth Amendment standard, I'm not saying that it has to be appealable. I'm not saying that it has to be a desired condition. The Eighth Amendment prevents inhumane conditions, and I don't think that, and I think the case law supports this, that going without water for 4 hours constitutes an inhumane condition.
I don't think, but it's the denial of a minimal life necessity. So you're trying to get into, well, do we have to have water every 8 hours? Do we have to have water? It's the denial of a minimal life necessity. A minimal life necessity is water, in which he was denied.
And in Jones versus Solomon, Your Honor, the individual was in a dry cell for, I think, 17 hours, but there is only 1 cup of water provided in an 11-hour period, and the court found that the officer there was entitled to qualified immunity. We were not able to find a case saying that if you don't receive water within a 4-hour window, that you are violating the Eighth Amendment. And the same for the shackling aspect of it, or the secured aspect of it to a telephone pole. And Hope versus Pelser, again, I don't think it can be divorced from the context in which it arises. That, as Judge Richardson pointed out earlier, there were sufficient reasons to place plaintiff in restraints the way that he was. I mean, he had a significant discipline history. He had assaulted 2 inmates on 2 separate occasions at that point, and had also destroyed property. So for him to say he didn't pose a threat to people, and one of those times he had also gotten into it with an officer while they were trying to break up the inmate fight or address the inmate fight, that there is a reason why he is at least secured or shackled to a telephone pole or to a telephone in a way that he was.
But this was a 1-hour recreational period. Why was he shackled for 4.5 to 6 hours for a 1-hour recreational period?
We obviously have our position on why he was below the district court, because it was summary judgment accepting his position as it was. They said that justification, obviously there's not a material dispute, but a dispute on that issue. And so they went with plaintiff's side of it, which I guess was because there wasn't a second officer around to let him off of the telephone at that time, because policy required that there be 2 officers in there when they're ever transporting someone from their cell to the telephone. That was the reason that the district court went with.
And this happened 2 weeks in a row.
Yes, Your Honor.
And what was the government's proffered reason for why he was left for 4 to 6.5 hours?
That he wanted to be on the telephone, Your Honor. I mean, throughout the video, he's actively making calls on the phone. I don't think that it is him just sitting there with the phone on the hook, making, not doing anything. He's actively calling people, or at least picking the phone up
But
and
that's,
putting it to
that's
his
the
ear.
dispute. I mean, that's the dispute that if it got past summary judgment, there would be a, issue about
Right.
Whether he was there at his own request or whether he was there at the behest of the officers.
Correct, Your Honor. And I think, but there wasn't the dispute is the fact that two officers needed to be there to transport him to and from his cell to the phone and back. And at that point, the accepted representation, I don't think it was disputed below, was that there was one officer available to do that at the time that he had asked to be taken off. I think also, just from the representation about plaintiff urinating on himself, that happened at 4:06 p.m. Going off the timeline that he created when looking at the video, up to that point, he had not represented to an officer that he needed to use the restroom. If you look, it's at JA 612. He notes time stamps of when certain things are happening, and he mentions asking for water at the 3:19 p.m. mark, but there's no reference of him needing to use the restroom before then. And so to say that they were, somehow ignoring a fact of a request that he had made, I don't think that that's supported by the video or his affidavit when looking at it together. There's also a point that he represents that he had asked to be let off. It was around the 141 mark. I think it's the 255 mark on the bottom bar of the video, but there's no interaction shown in that video between him on the phone and the officer coming in and walking around. I think that is, I know that the standard is blatantly contradicted by the video. I think that is blatantly contradicted by the video. There's no interaction. He actually plaintiff turns in to face the phone booth when he's making the call as that officer's in there walking around and then leaves, and there's no interaction between them. As far as qualified immunity goes, we raised this in our brief. There are very unique standards in the deliberate indifference frame, but we just think that the unique factual circumstances of this case did not make it clearly established that either of those shackling incidences would have violated clearly established law. In King versus Riley, this court noted, that despite the assertion of deliberate indifference, that the officer was still entitled to the two-prong approach for qualified immunity because it wasn't obvious that it violated the Constitution. Even if the officer knew of a actual risk of harm to individuals by not looking into windows when performing security checks, knew of that risk and it was a risk, and even if policy required it, the court said that the officer was entitled to qualified immunity in that situation. And then I've already referenced it a few times, Your Honors, but Jones versus Solomon is another case in a similar situation where an inmate was forced to perform 3 bowel movements after purportedly ingesting some version of contraband. And in the third one, he was not provided with anything to clean his clothes after having to go through his feces. He was left in soiled clothing for 23 hours. He didn't have soap or water and ability to clean himself for 30 hours, and this court still said that the officers there were entitled to qualified immunity, and that's a 2024 case that would have postdated the events in this matter.
And there's no hygiene concern in this case, right? This was, to distinguish it there, I haven't seen anything like that raised in the record. He was outside of his cell. He was retrieved 2 hours later. Is that correct?
That's my understanding as well, Your Honor, and no representation that he wasn't able to clean himself or change clothing once he was returned to his cell, or that he told officers that and they denied him the ability to clean himself up.
Let me ask you, I want to ask about the claim that the district court judge regarding the issuing of summary judgment before discovery was complete. So it appears that the district court's decision is that the first video, it looks like she relied on the first video and the absence of the second video. And I believe the argument is that there should be a negative inference. I don't know where the second video is. There was an order by the district court, correct?
Correct, Your
For
Honor.
both videos. And then you all did not produce the second video. And I think you and I had some conversation about that a little bit earlier. Maybe it doesn't exist but should there be some negative inference drawn by the first video being cut off? There is no second video, on this whole argument as to whether or not there's this issue of fact, as to what happened.
I don't think so, Your Honor, I guess the primary reason the district court accepted his representation of what happened. I don't think the district court said, just because there's a video, I'm not gonna believe what you are purporting to say happened.
Well, she didn't accept everything. She said she didn't urinate on himself. She said, I don't see it on the video.
And Your Honor, we're not defending that on appeal. I do think that is inconsistent with the blatantly contradicted case law that this court has articulated with respect to videos. But I think even taking that aside and with regard to the second incident, I think she accepted everything that he said is true with respect to that and still said, we're talking about a 4-hour period here, and that's not the objective element of the Eighth Amendment claim. And so I don't think that requires a negative inference, Your Honor. You're right, there was a court order. I think that's my answer, Your Honor. I don't think so, just because she accepted that. I think she accepted what his representation of what the video would depict and still found that it wasn't sufficient. And I still think I think then coming back to, that's the just basis of the claim, and then coming back to the clearly established prong, Your Honor, accepting all of that is true. It wasn't clearly established that those events would violate the Eighth Amendment at that time.
But I think his argument is that during this time, as to the second video, that he fainted. And because we don't have that video, that there's this issue, this issue of fact is there because we don't know if he asked, you all are saying he didn't ask for water. He said he did ask for water. And so there's these disputed, how long was he there when he fainted? Did he hurt himself? Was his arms? So wouldn't all of that, was the district court premature in summary judgment with all of those issues still out there in discovery?
I don't think that those were issues, Your Honor. The court accepted that he had asked for a cup of water and was not provided with it. That is in the district court's order. They accepted that as true. The district court didn't ignore that fact. I don't know that the video proves the injury. We do have the medical record showing when he was actually receiving medical care, at what time on that date he was. So I think there's some backstop to that to provide evidence.
You can always answer her question. As long as she's asking questions, you keep answering.
Yeah, sure. I thank you, Your Honor. That was my answer.
Thank you, counsel. Happy to hear from you, counsel.
Good morning, Your Honors. My name is Nick Field. I'm appearing on behalf of Omari Mason. May it please the court. So I'd like to start, many pieces of this case have been, I'd say, disputed. And on that point, we think at the bare minimum, this case should be remanded for additional discovery. We think this is the bedrock rule from Shaw, where a summary judgment is disfavored prior to discovery. In fact, it's particularly disfavored when the defendants are in control of certain pieces of evidence. We think that applies here. The second video has not been turned over. There's this language that's been used that the district court essentially subpoenaed, but they didn't actually subpoena the video. Additionally, Mr. Mason requested affidavits, statements from the jail officials. There's an allegation that he should have pursued this through some other method. I'm not aware of any case law that supports that.
Why does that matter in a context where the district court took the plaintiff's version of the facts as a given and says, at least in theory, maybe back away from this case, you might have specific arguments, but in theory, I understand the point of Shaw and the context of Shaw, but in a context where the court says, listen, even giving every benefit of the doubt to the plaintiff's version of the facts, it would not establish an Eighth Amendment violation. Why would they require discovery there? Because it seems like in that instance, they've accepted the facts as the plaintiffs alleged. Why would that require additional discovery? Or do you have to tell us why the discovery would do something more than the plaintiff's version of the facts?
Right, so I'd start by saying I don't think that's the situation here, but to answer your
No,
question
no,
very directly.
that's
Yep,
why I changed the
sure,
hypothetical
sure,
midway
sure.
through.
In that case, I still don't think there's a carve-out in Shaw that says if the district court accepts the factual allegations, because I think part of the purpose of discovery is to determine information, is to find out what happened. Mr. Mason was passed out for part of the time during these incidents. He couldn't make statements about that. We don't know. There was no clock in the room that he was held. We don't know how long he was there for. What if it was 9 hours instead? The evidence is not in the record, and therefore discovery is appropriate in this case. And I think there are also, just to return to this case in particular, there are factual disputes beyond just that. Counsel on the other side said that he didn't ask to use the bathroom during the first incident. Mr. Mason swears that he did. This is a factual dispute that.
But our review is de novo, right?
That's correct.
So we can grant you all of the facts in your favor when we do our review, right? Regardless of what the district court did.
You can grant the facts. Again, I'd return to Judge Richardson's hypothetical and my response that discovery isn't certain here. We don't know exactly what would come from discovery.
Well,
Mr. Mason has a
We
right.
do require, when plaintiffs claim that they, please don't decide this without discovery, they're supposed to identify what they need. And he identified these two prison officials and said that they would be, entirely consistent with what he has said. And this video, which the court ordered the defendants to turn over, and they said they didn't have. So we have a statement that he asked for consistent evidence and a video that we've been told doesn't exist. And that's it, right?
Well, that is the evidence that Mr. Mason requested. The idea that this video doesn't exist is confusing. On the record, Mr. Mason has a sworn statement that Defendant Binns told him he viewed the video to ensure that he wasn't faking passing out. That is, I believe, on JA 588.
That's not inconsistent with it not existing now.
Okay.
We know there was a video in there because they got a video from one week and not from the next. The question is whether it was retained.
Well, I think the discovery would then proceed to determine what happened to that video. Did the defendants purposely destroy that video? Where did it go? Who was in control of it? These are questions that should be answered on discovery.
Can you answer the question that I asked your colleague, that is accepting for a moment that this is an Eighth Amendment question and accepting for a moment that Hope does not establish the clearly, or does not clearly establish the right that you're asserting here? What else would you have me look at?
We would have you look at Robles. I realize that is a 14th Amendment case, but the
Okay,
but it's an
how
objective.
about go to, are there any Eighth Amendment cases?
Not that we know of. We don't believe that this is a common occurrence in jails or prisons.
Anything else? Thank you, counsel. We will come down and greet the lawyers and then proceed to our next case. We'll proceed to our next case, which is number 24-1939 and accompanying numbers, AbbVie versus Brown. We've got lots of lawyers, but we'll be happy to hear from Mr. Owen to start.
Thank you, Judge Richardson, and may it please the court. Matthew Owen on behalf of AbbVie. You will hear three arguments from the appellant's side this morning, and we've done our best to divide coverage of the various issues in this case. But I'd like to start, absent other direction, with two. The first is to explain why the Maryland statute compels manufacturers to sell at discounted prices their drugs to covered entities and contract pharmacies under circumstances that federal law does not require, which has both the consequence of being a taking of private property and also an alteration of the terms and conditions of participation in federal Medicare and Medicare programs, and therefore preempted. The second is to explain why the Maryland statute, like the West Virginia statute, sets up a alternative and preempted system of enforcement in state court of disputes and rights that are committed by Congress and by the Supreme Court's decision in Astra to the exclusive competence of HHS and its Administrative Dispute Resolution Tribunal. So it's taking the first issue first. The Maryland statute provides that a manufacturer may not directly or indirectly deny, restrict, prohibit, discriminate against, or otherwise limit the acquisition of a 340B drug by or delivery of a 340B drug to a pharmacy. In the record below, the state admirably, I think, acknowledged at JA
Pharmacy
8.
under contract with a covered entity, right?
Yes, that's right, Your Honor.
Not just a pharmacy on its own dime, but for a covered entity.
No, that's exactly right, Your Honor, but it's important to understand, I think, that manufacturers' policies, in order to comply with the federal 340B statute, must offer to sell to covered entities drugs at ceiling prices, but they are allowed under the 340B law, as the D.C. Circuit and the Third Circuit have recognized unanimously, to impose reasonable bona fide conditions. One of those can be that if you don't agree to a one contract pharmacy policy or a claims data requirement, we don't have to sell our drugs at a 340B price at all, not even to a covered entity.
And those courts said it's because the federal statute's silent, right? That's what the courts have unanimously said.
The federal statute in question is a spending clause requirement, and so a spending clause legislation. And so what it does is it says, what are the things that manufacturers have to do in order to participate in a federal program? And it is, because it is silent as to this sort of unlimited contract pharmacy obligation, that means manufacturers don't have to agree to that in order to get access to Medicare and Medicaid. They only have to offer terms on bona fide and reasonable, offer 340B drugs on bona fide and reasonable terms. And having
So your line there effectively is, the Third Circuit says silence doesn't speak, but the DC Circuit seemed to say a little bit stronger that silence actually does speak here, that it actually gives or retains the manufacturers their inherent right to offer the sale of their goods on their own terms, except as limited by the 340B program.
Except as limited by the 340B program. What these state laws do is say, well, actually, no, you have to sell more. To a covered entity, if they're going to allow it to be acquired by a pharmacy or by a pharmacy directly, what the statute requires in these states is that we sell drugs at a confiscatory price under circumstances.
Does it matter whether you have to sell more? Right? I mean, that might be factually true, but if everybody was doing what they were supposed to be doing, acknowledging that might not be true, would your preemption claim turn on whether it requires you to sell more or just that it requires you to sell it or deliver it to 50 different places rather than one place?
Because, as the state acknowledged below, these are attempts to control our offer in the first place and not just back-end delivery conditions, and that's quite important. It's at JA 868. What that means is that if we have to sell more drugs to a third party, another private company, at confiscatory prices, it means A, that's a taking, and B, it's not voluntary because we didn't get any state benefit from either, from Maryland in exchange for that property. And third, that means that they've raised the price of admission to Medicare and Medicaid. If I could very briefly address the enforcement issue. In Astra versus City of Santa Clara, the Supreme Court made clear repeatedly that the jurisdiction of the ADR tribunal to hear overcharge claims is exclusive. 42 CFR 10.21, which postdates the Eighth Circuit decision in McLean, defines overcharge to include any claim by a covered entity that a manufacturer has limited its ability to purchase 340B drugs at that price. That's what our policies do. If you don't agree to a one-contract pharmacy or claims data limitations, you can't purchase them. Thank you, Your Honor.
Thank you, counsel.
Good morning, Your Honor.
Mr. Perry, tell us what you're going to talk about. I feel
I'm
like
gonna-
this is
I'm gonna begin if-
speed dating or something here, but tell us what you're going to talk about first, and then tell us.
May it please the court, I'm going to start with A1 of the federal statute, and then the two particular cases, Santa Fe and Novartis, that Your Honor's just mentioned. A1, of course, creates the obligation to provide an offer of a federal discount. It's a provision that is solely found in federal law. Maryland cannot and has not done that. In 2024, the DC Circuit in the Novartis case addressed exactly how that obligation applies in a contract pharmacy context. And here's why that's important. It shows exactly what the state of Maryland is trying to do here, and that is create an obligation to provide this pricing on transactions where it wouldn't ordinarily apply. There's two.
Well, I'm confused by that because in the DC Circuit and in the Third Circuit, your clients called this a delivery condition. They said, we have contracts about delivery conditions. And the DC Circuit and the Third Circuit called them delivery conditions, referring to the number and kinds of contract pharmacies to which you would ship drugs, delivery conditions. But then in front of this court, the exact same requirement, you're saying, well, when we do it, it's a delivery condition, but when the state does it, they are regulating pricing. They're requiring us to sell more at lower prices. So explain that difference to me.
Sure. Both of the two statutes, the state and the federal, regulate both delivery and pricing. And you can see delivery addressed in Section 4 and Section 5 of the Novartis decision. And let me, if I might, just walk through the two critical holdings in that decision. First, the federal.
But can you answer her question first? Because I took her question to be more fundamental, right? Not about the statute, not about the decisions. The point is, in those cases, your clients argued a position that is directly in contrast to the position you're arguing here.
I don't think it's in contrast, Your Honor, because both things are regulated by both statutes. So you can say these are both delivery issues regarding
No,
contract pharmacies.
You said that the federal statute does not regulate delivery. Like, that was your whole
Solely.
argument in the DC Circuit and the Third Circuit, and you won. And now we're here, and you're saying, well, this is actually not about delivery at all. It's about price. And even though the statute from Maryland doesn't mention price, it's really about that.
There is a really key distinction that I'd like to point out, and that is that the DC Circuit case and Santa Fe Third Circuit case were about universal obligations to deliver, all right? Unlimited number of contract pharmacies. They were not about the question of whether some incidental delivery policy is or is not illegal under federal law. Both of those cases, if you read them carefully, they're about silence and whether the federal government can impose a universal delivery requirement. They can't. It was about universal delivery in that case, and that's what we were talking about.
So what's different here?
Well, there's two holdings, all right?
This is not universal, it's just Maryland?
No, the question here is what can you do in a federal offer? The second holding in Novartis addresses that very specifically. What is permissible?
No, the question here is about what's left to Maryland to regulate about pharmaceuticals within its borders.
Well, I will show you in their brief where they admit that what they're trying to do is change the federal offer and compel you to make drug sales that you're not required under federal law to make, but it turns on what happens in sections 4 and 5 of Novartis. And in that case, what the court said is one contract pharmacy limitation is okay. That's an appropriate limitation on your federal offer. Claims data precondition, okay, that's an appropriate limitation.
Yeah, they said that's
here is why
okay
this is
because the
key.
federal statute is silent. We're talking about Maryland has a statute that says it's not okay, and can Maryland do that?
It's not silent, Your Honor, because
That's what the court said.
But what they were talking about there is universal delivery. This is
No,
a
but I
specific.
thought your answer was going to be different. I thought what you were going to say is that in the DC Circuit case in particular, the Third Circuit's a little more ambiguous, that the court says that this silence preserves rather than abrogates the ability of sellers to impose those obligations.
Yeah,
And because it's suspending clause legislation, right, that silence in preserving that right means that nobody, neither the feds nor states, can like require that of the manufacturers.
And exactly, and here's
So
why
is
that's
that your
important.
position, that states cannot add any requirements to Medicare or Medicaid? No Medicare or
This is
Medicaid
different.
regulations by states?
This is different than Medicare and
Yeah,
Medicaid.
340B, you would agree with that statement if instead of Medicare, Medicaid, the question was that they can't add requirements to the 340B program?
Yes, and let me explain exactly how this plays out, if I might, in this shall offer requirement. The key here is that if I employ as a drug manufacturer a contract pharmacy limitation, a claims data precondition, I have satisfied my obligation to make an offer. I've discharged my obligation to make an offer. The state is coming in and making me do something different, and they admit it. And they admit it on pages 54 and 55.
Can I ask you a different question? I know you're out of time, and I don't know whether this is your area, but you're stuck with it one way or the other. Imagine a state had a generally applicable law, and I'm really asking about field preemption, not conflict preemption, so keeping it in that sense. But they had a generally applicable law that says if a contract involves more than $1 million, it has to be notarized, right? So it's a made-up law, it doesn't exist, right? But bear with me. If that law existed and you came in and challenged that law with respect to the 340B program, would it be preempted?
It depends on the law, but there are different rules when you're specifically targeting a.
No, I understand. No, I understand it would be different if I gave a different hypothetical. But that's not actually an answer to the question, right? So what I'm asking is that law, would that law be preempted as it applies to the 340B program?
If there were a generally applicable law, like you explained.
Yep.
That is not targeting a very specific federal program, not trying to change your obligations on a federal program, the preemption analysis could be very different, and you might be right. But here is what's
Wait,
happening.
no, but that's, all right, so that's just a duck of the question again in a different way. The analysis would be different, and you might be right, is to not like actually engage in the question. So let me maybe ask a different way. Do you think that notarization requirement would bind the ADR process? Like in the
Notarization-
ADR process, if there was some dispute involving a contract and the manufacturer or covered entity came in and said, it wasn't notarized, would ADR be bound by that obligation?
I am not seeing in your hypothetical something that conflicts with the statute, with the federal statute. But here, what conflicts with the federal statute is what the state has admitted on pages 44 and 45, and that it.
I totally get you want to make a different argument. We can, maybe just for a minute, try to answer this question, and then I'll stop. I'll assume that you don't want to answer it anymore. If you don't want to, that's totally fine. Would the ADR process, so if there was a dispute in front of the ADR panel and this requirement of notarization existed, would the ADR panel be bound by it?
There is a regulation that answers your question.
And
It is
what
at-
is that
It is at
regulation?
42 CFR 10.21A1. And what it says is the ADR panel's special proceedings govern any effort to limit the availability of 340B pricing. I don't take your hypothetical as fitting in that box. That's I think, the very precise answer to your question, all right? It doesn't seem that your hypothetical conflicts with the federal statute. All right, but here's the point, if I might, Your Honor, on pages 44 and 45.
I'm sorry, that's fine. You don't answer, that's totally fine. Go ahead. Actually, your time's up. Thank you very much, counsel.
Thank you.
Good morning, Your Honors. Jessica Ellsworth for Novartis. The 340B statute creates an exclusively federal scheme, as we've been talking about, for manufacturers to offer discounted prices to particular entities while preserving manufacturers' ability to set commercially reasonable terms in doing so. Congress requires Novartis to participate in this program and sign a pharmaceutical pricing agreement that specifically sets out Novartis's responsibilities for
Can I just-
participating in the program.
Can I ask a follow-up about what preserves this right of the manufacturer? So my understanding from the argument is it's the silence. The silence preserves the right of the manufacturers to fill in all the blanks.
I think that's right. Judge
So it's not
Richardson,
because it's so comprehensive. It's not comprehensive. There's so much silence, right? There's very few things required by this program, and then there's a lot of silence. And the manufacturer's only argument is it's the silence that preserves this realm for us, and no one can regulate it.
so I don't think that's quite right, Your Honor. The argument is that there is a federal program that Congress created as a condition to participating in Medicare, Part B, and Medicaid. And Congress said, this is the size of the program, these are the manufacturer's responsibilities to participate. Manufacturers like Novartis said, okay, we're going to participate in the program on these terms. Maryland has decided these should not be the terms. The terms should actually be bigger. The subsidy that Novartis provides should be larger. And so Maryland wants to change the terms of what is required to participate in this program. The requirements are set out, they are comprehensive as to the program, and that's what the Supreme Court recognized in Astra. This is intended to be a uniform program, it has a uniform enforcement system, and that is what Congress wanted. So in Astra, in the DC Circuit decision, in the Third Circuit decision, in this case that involves preemption, in all of them, the through line is what did Congress intend when it created this program? And it intended a program to be a certain size and run in a certain way. And Maryland's law wants to unilaterally broaden Novartis's responsibilities in the program. It wants to expose Novartis to additional enforcement mechanisms that the federal program does not have. And it wants to limit Novartis's ability to use things like a claims data requirement in order to actually advance its.
The intent of Congress was to stretch the resources.
Yes, Your Honor. So this
Under
program.
30 I thought the intent of the statute under 340B was to stretch resources to areas where.
So
But
there's.
it seems as if your argument is to limit the states.
So, Your Honor, there's a balance, and it's important, I think, to note that this program ran from its inception all the way through 2010, exactly in the way that Novartis's policy works today, which is that if you are a covered entity and you do not have an in-house pharmacy, you can use a dedicated contract pharmacy, one of them, in order to, for Novartis to be able to offer you drugs at this discounted price and for you to be able to take advantage. But this program is a balance that Congress struck because one of the things that the program is designed to do is to make sure that there are not duplicate discounts given. So when you get 340B pricing, you don't get Medicaid rebates. There's a balancing that goes on, and HRSA is the agency that is set up to effectuate that balancing. That's what Astra recognized. It has to be done with an entity that has an eye across these programs that are collectively operated. If I could
I do
use.
want to ask someone in follow-up to Judge Rushing's question regarding to your co-counsel. It almost seems like your arguments here today conflict with the arguments you made before regarding reading into, not reading into Congress' silence. It almost seems as if there's some conflict between the arguments that you made before the DC Circuit and these arguments that you're making here.
So, Your Honor, I'm glad that you've asked that because I want to clear up that I do believe there is no conflict at all. The argument in the DC Circuit was that an offer is allowed in the federal program to have price terms and delivery terms. That can be the way the manufacturer structures their offer. What the Maryland statute does is it says that an offer cannot have what it calls delivery terms. Delivery meaning that a drug on the invoice is invoiced at a certain price. And you can see that because of the way the Maryland statute defines 340B drugs. So the statute itself is linking the delivery to price. This isn't about refrigerated trucks. This isn't about certain hours of the day where deliveries have to occur or packaging that a product has to be in. This is about the price. And the way you know this is because
This is about exactly the thing that the DC Circuit case and the Third Circuit case was about, right? It's about the contract requirement you want to have that says we won't deliver to these pharmacies, we'll only deliver to one, a 340B drug. we can call it price, we can call it delivery, but let's all agree it's the same thing as what was going on in the DC Circuit case and the Third Circuit case.
It is, and the argument is the same argument, which is that manufacturers have the flexibility under the federal program to set the terms of the offer in this way.
And now the argument, it sounds like, is because it's spending clause legislation. That's the argument that's being made now.
I think that's
the
actually.
preemption is different because it's spending clause legislation.
So, Your Honor, it's always been spending clause legislation, and I think that is why the DC Circuit said in the sentence that follows the language about silence on delivery, Judge Rushing, you actually quoted it, that silence in this kind of statute means that the flexibility is preserved for the manufacturer and not abrogated. And so that's why it's very important. I see my time is up.
Can I ask, sorry, one more question?
You can ask as many as you want. This is complicated.
I get why in the context of the federal regulation, the federal statute, that a court would say, well, if it's silent, that preserves a realm for the manufacturer, because that is the bargain that they agreed to with the federal government when they accepted the federal government's terms. What is your best case, your best example for the argument that that also preempts any state legislation on, anything in the neighborhood of the topic, right? Like states can regulate pharmaceuticals, but they can't regulate 340B pharmaceuticals because the federal governments and the manufacturers have an agreement.
So, Your Honor, can I give you two answers to that question?
That'd be
Because I think
excellent.
there are actually two answers. One is a field preemption answer and one is a conflict preemption answer. The field preemption answer is that this statute is simply an adjustment of the bounds of the federal program. It does not seek to do anything other than alter. It wouldn't exist but for the federal program. The only thing
Well, yeah,
it is
but that's
doing-
true about lots of things that wouldn't be preempted, that it doesn't exist but for the federal statute. Like there's Dublino, where there was a federal benefits program and the state added a work requirement. And the Supreme Court said, that's fine. It wouldn't exist without the federal program, but that's fine. But do you have a case where it's because it's a spending clause, like a bargain handshake between, the private entity and the federal government, that therefore we do a sort of different preemption analysis, or that factors in?
So, Your Honor, I have that case, and I'm going to give it to you in rebuttal because I do not have the name at the tip of my
Oh,
tongue.
I'll be on the edge of my seat.
And if I can also tell you just the
Is
conflict.
it Buckman?
Buckman is a good one. It isn't the one that I was thinking of, but I think Buckman is an excellent one because it
Trying to
also
help.
does make this point. I believe there is one other that is focused on the spending clause legislation piece of it. And so let me get that for you. On the conflict preemption, just to say very clearly, I think there are 4 ways in which there is a conflict here. That the Maryland statute is an obstacle to effectuating the purpose Congress set out in balancing all of the various needs with 340B and Medicaid. And the 4 reasons are that there is allowed to be one contract pharmacy limitation that a manufacturer imposes under federal law. The second is that a manufacturer is allowed to ask for claims data in connection with claims. The third is that the federal enforcement scheme, ASTRA tells us, has to be uniformly effectuated by HRSA. And the fourth is that the remedies are set out by the federal statute, and there is no indication, unlike in Medicaid, that there is any role for the states to play in
And
that.
that kind of sounds like saying it's an obstacle to the purposes and objectives of Congress because Congress preempted the field, right? I mean, that's kind of the same argument. Those aren't.
Well, this court has said that the two, conflict and field preemption, can be mutually reinforcing the principles, and I think that is the case here. So you can comment at in either direction. It leads you to the same point at the end. Thank you, Your Honors.
May it please the court. Your Honors, Maryland's HB 1056 withstands all of the appellant's various constitutional attacks. First, because HB 1056 regulates only the delivery or distribution of drugs. It is not preempted by the 340B statute. That statute regulates the prices at which drugs must be sold to covered entities and is entirely silent as to delivery. Next, there's no takings because aside from the drug companies, voluntary participation in the 340B program. There's no transfer of property in any way not contemplated by the statute. And the drug,
Why, can you just, sorry, I don't mean to get you off track, and,
I'm happy to jump in.
why do we think that it's voluntary in that sense? Because if you're a manufacturer here, you agree to enter into the 340B program, which is the federal program. But then as a result of that choice, which is voluntary, or at least arguably voluntary, given the size of the market that you're being led into, every state can then like tack on sort of whatever it wants to, including inconsistent obligations with respect to what you're calling the delivery piece, right? So one state might say you can only have one. Other states might say you can have as many as you want. Some states might have different requirements than others. Why does their agreement to the federal program constitute an agreement to sort of the state additions to that program?
Well, I think it's a theme that is threaded throughout every issue here, and that's the silence in the statute. The silence that.
Well, but the silence doesn't get you the agreement, right? So they agreed to the 340B program. And the 340B program, whatever we want to call it, it's in a federal statute, right?
Right.
But in no way, it doesn't seem like to me that they agreed to any state addition to that program, right? Because there was no, like, they were in the program before you passed the statute, they've stayed in it. Maybe you say there's like an implicit agreement there, but the agreement is with the feds, right, to enter that program. Why do we think that's an agreement to your state obligations? And what's the consideration that you're providing? You're not giving them anything for these additional obligations, right? This is just a pure punitive statute.
Well, that's, I disagree that it's a punitive statute, but it provides.
Can you be forced to pay a fine and go to jail? That seems like a punitive statute.
Yes, it's punitive. I thought you meant in the purpose, in the substantive requirements, but certainly there's an enforcement requirement if you don't comply with the requirements, but it's silence.
But that's distinct from like a spending clause voluntary engagement, right? So like, nobody who says the federal 340B program is punitive, right? They have to make the choice. Do they want access to this massive market that exists, or they don't? And there's a trade-off that they make, and they look at how much money the 340B program is going to cost them, and they sort of make a balance, and they say it's worth it to be in this market, right? That's a voluntary process. And then you come in and say, whatever balance you thought you drew, you now have to draw a different balance because we're going to add obligations to the program.
But I think that the issue is touched on with regard to what are those obligations. Those obligations could be anything that relates to an offer, and when the federal.
So your point is the state can do anything that relates to an offer?
Where there's silence as to what the offer is, the state can step in a way that does not conflict with the purpose and objectives of the federal government.
So you would agree, like, for example, that if the state said, you cannot request an audit under the 340B program, that'd be preempted, right? And so, just to make sure I understand, and this is sort of, I think, back to Judge Rushing's point, that the question sort of comes back to, in your mind, if the 340B program says it in it, like requesting an audit, then the state can't do it. But so long as the 340B program doesn't require a given thing, right? Then the state can add to that in any way it chooses.
I would agree with that in principle.
Yeah, I wasn't trying to be too specific.
Right, but
And then can I just ask one more question, and then I'll shut up? I know they have questions too. So can you tell me why I should read Novartis or forget Novartis? Like why I should like read the statute in this sort of spending clause legislation for that silence not to like actually speak? I know there's a great line at the beginning of the Third Circuit opinion that says silence doesn't speak, but I'm not sure that holds when you read the rest of the opinion. We sometimes open opinions with interesting lines that don't hold with the rest of the thing. But certainly in the DC Circuit, the court seems to say there that it's not just that it's mere silence, and so there's no guidance one way or the other, but instead that silence actually preserves the pre-existing right to make an offer under terms that you wish with the product that you're selling.
Well, I don't read it that way. I read that
Can you help me understand why? Because it says this silence preserves the ability of sellers to impose delivery conditions, right? I mean, that means that it's like doing something, right? The court there seems to read that silence as saying, we begin with the baseline principle that if you sell something, you get to sell it on the terms you choose. We're telling you, if you enter this 340B program, that you have limitations on that ability to make the offers that you choose to make, but here are those limitations, and no more, right? You gotta do it on price, you gotta do it on these things, right? So there are limitations, but that we don't otherwise take away your right to sell your product on the terms that you wish to sell it.
I think the appropriate reading of the DC Circuit and the Third Circuit is that it prevents the federal government from penalizing a manufacturer from putting these delivery restrictions in their contracts. And why does it preserve that? Because there's nothing in federal law that speaks to delivery. So it's a protective, you say, it says preserve, my gloss on it would be protect from federal government regulation that does not exist, because it doesn't exist. But that silence does not mean that the states cannot step into that void and create their own regulation of delivery, something that the federal government chose or Congress chose not to do, and the states can step into that void.
But if Congress chose then I'll stop. I'm sorry, Judge Rushing. I know you're trying to speak, I promise.
That's all right.
Actually, I'll just let you go.
No, go ahead.
No, I'm not gonna do
Please.
that. No, I'm not gonna do that.
All right. I just wanted to ask a sort of basic backup question. We're talking today as though the manufacturers get to decide whether to enter the 340B question. I've read the briefs, or 340B program. I read the briefs to agree that if manufacturers participate in Medicaid and Medicare Part B, they are required to participate in the 340B program. I mean, the manufacturer's brief says, in exchange for participation in Medicaid and Medicare, the federal government requires manufacturers to provide 340B drugs at these low prices.
That is my understanding. I suspect my colleagues might have a more in-depth understanding of that relationship, but.
So like, could a manufacturer agree, like say, I want to participate in Medicare and Medicaid, but I'm choosing not to participate in the 340B program because I don't agree to its terms and conditions?
I don't believe that that's a choice that they
No,
can make.
in other words, the incentive to join the 340B program is we will give you access to Medicare and Medicaid markets.
Right, but
Right?
very
That's
lucrative, very
That's the spending legislation, where we say, if you want to get reimbursement from Medicare and Medicaid, you have to agree to this 340B program.
That's
But
correct.
it is voluntary in that sense, right? That they could choose to not enter the
They could.
Medicare, Medicaid market, and then they would not be burdened with the obligation of the 340B program.
That's correct.
Does Maryland at all cooperate with the federal government in Medicare and Medicaid? Or is it solely a federal program?
I think you're getting a little bit outside of my knowledge base, but I believe Maryland.
I think
Let me help you.
does.
It
Yes.
obviously does. It obviously does. The question is, in those instances, does the Medicare and Medicaid statutes specifically provide for state involvement? And I'll just tell you the answer to that is yes, right? The question is, does the 340B program include any reference that gives states roles in the 340B program as distinct from Medicare and Medicaid as a whole?
I don't believe there's anything in 340B specifically that.
And is the 340B program a benefit that's provided only to Medicare and Medicaid patients? Or in fact, it has unconnected to Medicare and Medicaid patients? It only asks whether you're a covered entity patient.
That's my understanding, is that, and again, going to the purpose, we haven't, I don't believe, talked enough about the purpose of 340B, which is generally to subsidize these covered entities so that they can remain afloat, so that they can remain their ability to provide these services, their rural hospitals, their local clinics, specialty clinics, that need this federal subsidization to survive and to serve their patients and to serve their, and to expand and continue.
Can I just
And-
ask this question? Why in the world would a government, and this is not my question that is going to matter here, but why would the government like subsidize in this way, like allow manufacturers to charge higher prices in Medicare and Medicaid and then backdoor it through the 340B program to some subset of entities? This seems like a crazy way to subsidize. I totally think the covered entities ought to be subsidized. Why would they subsidize in this way? This seems like a crazy way to do it, doesn't it? Like rather indirect? I mean, this is like all the way around.
My understanding is that the basis of it is that it takes the drug manufacturers who are making a lot of profits off selling their drugs and redirect some of those profits, redistribute some of those profits to the covered entities through a limited program. And it's limited in the sense that covered entities get, it's only available for covered entities and their patients. And so it's a-
$24 billion worth of limited, right?
Right, but it's a closed program in the sense that when they talk about we're going to have to give away or sell more of our drugs under this program, there's a cap to it, and that cap is the patients of these covered entities. So there's always going to be a limit in that respect.
And it's like, what, 5%, I think?
Roughly, Your Honor. And so to pivot to conflict preemption, if we're talking about what does Maryland's law, does it conflict, or is it an obstacle with the federal objectives here? The federal objectives, as Your Honor
Maybe
pointed-
this is the same question, maybe you're getting there, but can you tell me what would you have us say about Astra, right? So Astra seems to say in a variety of different ways, in effect, that like the program is to be administered harmoniously and in a uniform nationwide basis. And we have particularly with respect to the ADR process, and we have an ADR process that includes, this idea that we talked about earlier in the regulation that our friend read about sort of not selling to certain entities, right? That's covered in the ADR process. Astra seems to tell us the ADR process ought to be the way that we do this because of the complex interactions that we have between Medicare, Medicaid, and this 340B program. What would you say about Astra? Like, why do you think Astra doesn't suggest to us that this differential enforcement mechanism where the AG gets to run around and fine and throw people in jail is like inconsistent with Astra and its understanding of the 340B?
Right, well, aside from the theme of silence, the other theme is that there's a.
Well, but that's not silence, right?
I know.
So Astra doesn't say silence. Like Astra says, there's an ADR process, and it says, we want a single way of doing this. And like, if you're trying to do this some other way, that's improper. That's not silent. I understand the
No, no,
silence argument in another context, but silence doesn't seem to help you in Astra.
My apology, I was merely saying that there are two themes in this case. One is silence, not applicable here. The other theme is a difference between pricing and delivery. So Maryland statute is about delivery. 340B program is about the pricing. And what was at issue in Astra was the ADR program about pricing in the context of diversion, the rebates. And that's not something that.
But that doesn't seem like, to me, that like helps you, because we know the ADR process includes claims for failure to sell to a given entity, right? That's part of the ADR process, just like the price is part of the ADR process. So why does that help? Why do you think Astra, when it said we should have a single way of doing this, why do you think Astra is limited to price? I mean, it talks about price, but it talks more about, it seems like to me, this sort of overarching, single, uniform, nationwide system of enforcing the 340B program. We don't want a bunch of, in that instance, private plaintiffs running around like yahoos. And you might say, we don't want a bunch of state AGs running around like yahoos.
Well, my understanding is that there aren't a lot of issues with drug manufacturers refusing to sell to covered entities or refusing to sell to pharmacies. That's how they.
But you agree it's covered by the ADR process?
With regard to the pricing and with regard to diversion, that's my point there, is that it's
But
not
why,
about.
why do you think it's limited to those two things? Why is that? If they just refused to do it they didn't think they were a covered entity, right? I mean, they could just, all of that is subject to the ADR process.
To refuse to sell outright?
Yeah, because they think this isn't a covered entity, the covered entity thinks it is. Somebody has to resolve that question, right? I mean, the covered entities aren't like listed out by name, they're categories, maybe there's some confusion about it. That question would be resolved in ADR, right?
I'm just not aware that that's happening, because I think the drug, but I mean.
It doesn't have to, my question is, if it happened, it would be resolved in the ADR process. Right? And that's what the FedRed says. That's what he just quoted to us, right? I think it was Mr. Perry?
I suppose because it would be a baseline refusal to make an offer and at all. And I suppose that's covered in the fundamental nature of the federal statute, is that they must make an offer to covered entities to sell their drugs. And if
Okay,
they're not
and so
making
why doesn't that
any-
same idea apply when it says they made an offer, but the offer was limited to a single contract pharmacy? That too seems covered exactly within the ADR process. And instead, you want that to be a question not decided by ADR, but instead by, 50 different state AGs who apply different bars and lines and standards to doing so.
Because under the failure to make any offer context, which I understand your question to be, that's a violation of federal law. But the violation of the terms of that offer, or that the offer wasn't good enough, is an issue if it relates to delivery under Maryland law, because that statute is silent as to delivery, which allows Maryland to come in and regulate that aspect of the program or of that transaction. And so they're distinct. And that's the theme I was trying to get at, is that the ADR program, the 340B statute, relates to pricing and disputes about pricing, whereas Maryland's enforcement mechanism only comes in if there's a issue with delivery or the refusal or denial of delivery.
Maybe this, right, can you help me understand this idea? I mean, generally speaking, when we say, when we talk about price, it includes not just the numbers that are on it, right? But it's like the obligations that have to go with it, right? So imagine the story was, you're a covered entity and you say, all right, I've got 1,000 units, but hey, manufacturer, I want you to deliver them to 1,000 different locations, right? I think we would say that that's more expensive for the manufacturer to do than it would be to deliver to a single location. Is that fair?
Yes.
Okay. And so why isn't that also sort of part of this story here, right? That the manufacturers, they're not really sort of leaning on this heavily, but in part what they're saying is, you're telling us to deliver to 1,000 different pharmacies, and part of that might be shipping costs, but the real problem is with identifying and testing for diversion. Because if we have to deliver to one pharmacy, we can really focus on whether they're diverting these drugs to the wrong places. But if we have to deliver them to 1,000 pharmacies, it's impossible for us to determine who needs to be audited and when, right? And so why isn't that sort of a fundamental idea that is in effect about price? Because you're interfering with their ability to cost effectively identify what they should be doing.
Well, I think these highly contextual questions go also to the fact that this is a facial challenge, and I think that might be better resolved in an.
All right, totally fair, but answer the question anyway.
Well, I think one of the answers is I don't think that's realistically how it looks on the ground, because I think that the drug manufacturers are delivering to all of these pharmacies anyway. Remember, outside
Well, but they're delivering non-340B drugs, right? What their concern is, right, is that they're delivering 340B drugs to a pharmacy in Hawaii, and they have no idea whether that pharmacy is actually serving your patient or not, and it's almost impossible for them to cost effectively determine it.
The question of whether they're serving their patients or not, that would be a question of diversion, again, in the federal context. But I believe that.
But you understand it's harder if you're the manufacturer. I mean, just real world, it's harder to identify whether diversion is happening the more dispersed the pharmacies are. If you got 1,000 pharmacies, it's hard to keep track of whether they're diverting. If you had a single pharmacy right? It'd be much easier to identify when diversion is happening, right? Yeah, I mean, that's not a crazy idea, right?
But not at all. But the answer is that's what the federal scheme is for. I see my time is up. I'm happy to.
Wait, why is that what the federal scheme is for? Because it seems like to me the federal scheme has sort of answered that question and sort of said, and now we're just sort of full circle, but has answered it by saying, you know, they have the right to do that the federal system preserves that right.
I would disagree. I think that the Johnson case and the Third Circuit case talk about the silence, and it talks about the ability of the federal government vis-a-vis their regulations to penalize drug manufacturers for refusing to send their drugs to contract pharmacies. But because there is no such language in the law, the DC Circuit, Third Circuit said that you cannot penalize them for that. But that doesn't mean that the states can then step into that void, into that silence, regulate in their arena, and have a separate enforcement mechanism for that sliver of the.
Can I just ask one more question? I mean, what the court says, and you know, whether you think it's right or wrong, I mean, maybe you just think it's wrong, but it preserves the ability of the sellers to impose conditions. You want the opinion to say not that, but instead it prohibits the feds from punishing, right? But those are different in the way that we're really talking about here, right? So like, if it merely prohibited the feds from punishing, that's a different question than preserving the seller's ability to impose, right? These are the two sides of the coin. The question is the silence doing anything or whether it's merely silence?
But it preserves it under that landscape that existed under federal law, in the sense that if the statute is silent and the federal government can't regulate it, that aspect is preserved and not affected by. And I know I'm using different verbs, but that's my understanding of it. Thank you, Your Honors.
Now we have true speed dating and
True.
I'll just start by saying you should talk to your clients about having a single lawyer do these things. This is like not terribly helpful to have this disjointed, three different people with different ideas about what they're talking about. But we're happy to hear a little bit from you, Mr. Owen.
I'll do my best, Your Honor. I want to address a couple things that don't turn on the issue about silence that we've been discussing. The first is very quickly to address this scope of the ADR rule that Judge Richardson, that you discussed with opposing counsel. The language of the rule, again, is 42 CFR 10.21. Absolutely covers any limitation on the ability to purchase a drug at a 340B price. The only thing that these statutes do is provide a cause of action for an attorney general to sue a manufacturer about limitations on the ability of covered entities and their pharmacies to obtain 340B drugs at that price. If there were any doubt about this at all, it's in the record at JA 582. This is very helpful. There is a comment letter on the ADR rule submitted by covered entities, and at the bottom it says they urge HRSA to retain that formulation that we've read to you precisely because it will allow the ADR panel to exercise jurisdiction over these kinds of conditions on federal offers. So in other words, the entirety of this statute, everything that the states are trying to funnel into state court is supposed to go to the ADR panel, and Astra says it's exclusive. Now, as for another issue that has nothing at all to do with preemption, which is the takings claim that we have, the state's defense is voluntary participation. And again, Judge Richardson, as you explored with counsel for the government, voluntary participation in a federal program cannot mean that any state can say, well, as long as you participate in a federal program, we can take your property. And if you read the statute, and the text of the statute and not its kind of generalized gestalt is what really matters, there's two provisions I would point you to. The first is A4 Romanet 2, which makes clear that the statute's definition of 340B drug, quote, includes a drug that would have been purchased, but for the limitation in subsection C, which is why in the red brief at pages 54 and 55, they say the purpose of this law is to compel the completion of transactions that would otherwise not have occurred. They say it twice. That means they agree this statute, which again in section C1 says we can't deny the acquisition of our own property by somebody else. That's like a double negative way of saying we must allow it. And that's how you know that this statute compels transfer of our property in exchange for nothing.
Thank you, counsel.
One question, you said in exchange for nothing.
Yes, Your Honor. Because
It's
the
not, it's not, I mean, the pharmaceutical companies aren't making the argument that they're not receiving anything. You're saying nothing.
Well, actually, Your Honor, I want to be very clear about this. It has to be that in order for the voluntary participation defense to our takings claim to have merit, the state of Maryland, not the federal government, would have to give us something. There's a good opinion by Judge Srinivasan for the D.C. Circuit called Valancourt, which describes it as you need to identify an incremental benefit that you got in exchange for giving up your property. Maryland, I think, has conceded they don't provide us any benefit. Congress does, because Congress gives us access to Medicare and Medicaid patients. And they say, if you want to do that, that's the dog, right? And the tail is supposed to be the 340B program. If you want to have access to all these patients, that's what you get, but you give up something smaller. You have to give up some of your drugs. Now, the effect size, which the record is very clear about, of these policies that the state wants us to force to have, is to transform the 340B program into something bigger than Medicare Part B and Medicaid. In other words, the tail wags the dog under their conditions. But our observation is that in order for the state to say you cannot bring a takings claim because of voluntary participation, the state has to provide us something to buy our drugs with. And they haven't provided anything. All they've said is, if you've participated in a federal program, not ours, you must not deny someone else the acquisition of your own property at a confiscatory price. And that's a taking, even if whatever the court may think about preemption or any other claim, whatever means a state may choose to effectuate economic regulation, it cannot be like the Horn versus Department of Agriculture Raisins case, that just in exchange for doing business in the state, you have to give your property to someone else and let them dispose of it in exchange for pennies. That's a taking. They can't do that.
But when you have to show some type of economic impact, the loss of, I guess, millions or billions of dollars?
Well, there are two responses to that, Judge Benjamin. The first is no, because it's a physical taking. That is, the statute, this is Horn versus Department of Agriculture is a clear case on this, and so is Cedar Point from the Supreme Court, that there are two kinds of takings claims. One is a physical taking. That is, if the plaintiff loses the right to dispose of their own property. Like in the Raisins case, that was what happened, and the court said that means it's a physical taking, and we don't ask about economic regulation effects because the Constitution is concerned with means and not just ends. So if you command someone to let someone else acquire your property, and acquisition means they own it, they have the right to dispose of it, that's the language of Horn, then you don't have to make any further showing. And in Horn itself, the state made the same argument that, well, because we let you do business in the state, that's the benefit that you get, and so you voluntarily participated and waived your takings claim. And the Supreme Court said, no, transacting in raisins is something you could already do. That you can't hold that hostage to be ransomed by the waiver of constitutional protection. That's the first answer. The second answer is, even if we did have to show some more economic effect, the record here is very clear. This costs, that's why they're so interested in it. It costs billions of dollars annually, and the way that those billions of dollars are generated is someone acquires our property for a penny, sells it to patients, even ostensibly poor patients, at full price, and they keep the difference instead of us. So we know that on the face of the law, what you're trying to do is to, of course,
Who gets the difference, as a factual matter, and that happens in the pharmacy context, who gets the delta? Does the pharmacy just have a contract with the covered entity and the pharmacy keeps part of it and gives the covered entity part of it? That's totally a question of private contract between them.
That is exactly right, Your Honor. What happens is that, that's exactly right, Your Honor. What happens under the 340B program is, in these contract pharmacy arrangements, is that someone is allowed to acquire our property for penny prices at a confiscatory rate, and then they sell them to patients everywhere at full price before they know whether or not that person is a 340B patient, which is pretty important. So anyone who goes into a pharmacy, they pay full retail price for a drug that the pharmacy bought at commercial prices, plus a markup, and then someone remits to the covered entity, the hospital, the pharmacy remits some portion of the spread, and they keep some. The third-party administrator, which often is owned by a pharmacy chain like CVS, they keep some, and the covered entity keeps some. The patient pays full price, and we lose the full value of our chattel to someone else in a forced sale and some other.
That's all the product of the 340B program, right?
No, Your Honor, this is important. The 340B program The federal program doesn't require us, as Novartis and Sanofi said, to cooperate with this unlimited contract pharmacy arrangement system that gave rise to this
But the covered
model.
entity, that what you're discussing, that customers pay full price, the covered entity and its pharmacy, pay a penny, and they get to keep, all the profits between themselves, that's the 340B program. That's not because of anything the states are doing.
Well, I agree in part. I think it is true that that happens under the 340B program, although notice that, no legislation pursues its purposes at all costs, and that's a pretty dangerous purpose for Congress to say that we're going to create a revenue stream, and this, again, is the tail, the 340B revenue stream meant to be smaller than the Medicare Part B program and Medicaid, to which it's attached merely as a condition. But if you interpret it to say, well, anything a state does that increases the revenue of one for-profit.
No, I didn't ask about the purposes.
Yeah.
I wouldn't necessarily pursue that line here. But I'm just saying your complaint about, who gets the profits and who's benefiting and who's losing, that's all the scheme that Congress set up. And maybe the replenishment model, which is not regulated by anyone. Like that's not a requirement.
Well, no, Your Honor, actually, I think our complaint, to be clear, for the increment of sales that we have to legitimately offer under the federal program, we don't have a complaint about that. But for the incremental marginal extra sales that the state of Maryland says that we must complete, we may not deny the acquisition of these drugs by another person, even if we could under federal law. For those sales, because that's not the product of our voluntary participation in any federal program, we have a takings claim about those
You're
sales.
reading that to mean like some extra sales that you wouldn't make to the covered entity.
That's
that
right.
Somehow they're going to require more than your max to the covered entity.
It's not, Your Honor, just that I'm saying that. That is on the face of the Maryland statute. That is what A4 Romanet 2 says.
Yeah, I mean, you could read that to mean like you refused to deliver drugs that the covered entity was owed. You refused to deliver them to a particular pharmacy.
But again, I would point you actually to the record below. I think it's at page 861 or 868. We had this exact exchange. Maryland admitted to the district judge below that no, they're not talking just about delivery, that they were trying to control the terms of the offer itself. And that's also the same thing they say at page 54 and 55 of their red brief, which is what Mr. Perry was pointing the court to. At every place, it is true that the government, and in some places would like to say, oh, this is just a regulation of how drugs that have already been sold have been delivered. But that's not so. We actually will not sell them at all. This is our policy. If you, a covered entity, want us to deliver drugs to more than one contract pharmacy, our official policy is we won't sell them. So you can't buy them at the 340B price. There's nothing to deliver. These drugs won't be sold at all. And therefore, but the problem is that the text of the statute and the admissions of the state say that no, the Maryland law says you have to sell them under those conditions. It's not just about delivery. And one way you know that is it says acquisition, comma, or delivery. And the acquisition both comes first, is set off by commas, and it cannot be superfluous with the delivery regulation. The statute requires acquisition.
Thank you, counsel.
The state's law is not a law of general applicability. It's attempting to control what is and isn't part of a federal offer. That's why we're focused on sections 4 and 5 of the Novartis case, because as Mr. Owen indicated, if you make a federally compliant offer and the covered entity or the contract pharmacy, the purchaser doesn't accept that offer, you've discharged your duty. There's nothing more for you to do. But here is exactly what the state is trying to do here. It says so on pages 54 and 55 of its brief. It says its law precludes manufacturers from including delivery restrictions and offers to covered entities for the sale of 340B drugs. It is making illegal the specific types of delivery restrictions that federal law allows you to make. And it says more on page 55. It says that its statute causes, quote, the completion of purchases that would not have occurred under federal law but for those restrictions. In other words, its statute, prohibit, deny, et cetera, that Mr. Owen was quoting, changes federal law. It makes you incur obligations beyond federal law.
Thank you, counsel.
three very short points to make because I know you've heard a lot of rebuttal. The first, Judge Rushing, is the case that I promised you. It's Cummings versus Premier Rehab, 596 U.S. at 219. It's a Supreme Court case from 2022 that talks about spending clause legislation being based on consent. The second point is.
So that's not about how preemption operates with spending clause legislation?
I think it is when
it?
you look at, yes, it's talking specifically about the importance of consent in spending clause legislation.
Thank you.
The other thing that came to mind as we've been talking today about silence and the DC Circuit and the Third Circuit's decision is that silence can really mean two things in a statute, and it's important to distinguish between the two. One is that it can mean the federal law sets a floor, and that's what this court held recently in the Gen BioPro case that's the subject of a 28J letter in the West Virginia case, and it looked for textual clues that there the federal drug approval process did do exactly that and set a floor. None of those clues in the text or in the history are applicable here. The other thing that silence can mean is that these are the terms of the program, take them or leave them. That's what the Supreme Court held in the Arizona versus United States case. We think that is the way to understand the DC Circuit's decision in Astra. And then the last point I'd make is just a practical one. And Judge Richardson, this gets at some of the things that you were highlighting. I looked up yesterday Johns Hopkins as an example of what this statute does and means. Johns Hopkins, on the publicly available database of contract pharmacies, has 186 contract pharmacies. 3 in Orlando, 2 in Honolulu, 4 in Las Vegas, others in Pennsylvania, California, Massachusetts, Michigan, New York, New Jersey, North Carolina, Texas, and several other states. As you pointed out, Judge Richardson, for a manufacturer to understand what is happening at all of those pharmacies, whether the requested 340B pricing has anything to do with actual patients of Johns Hopkins is extremely difficult. That is why the federal program is set up the way it is. Thank you, Your Honors.
Can I ask one quick question? Do you have, I mean, I've tried to think of like other examples of federal programs that look like the 340B program to like try to think about something else, right? Mainly because I'm tired of thinking about what you want me to think about. Do you have any other examples of these types of federal programs? I mean, I tried to think about like a 501c3, but you get in the revenue code, it seems a little complicated to think about that as a federal program that you opt into voluntarily and that somehow preempting state law. I couldn't quite make that work. Are there other federal programs that you would at least have me think about?
So I have spent a lot of time on that same question, and I have not
figured
come
you
up
had.
with a good answer to it. I think the best contrast is something like Medicaid, where there is specifically upfront an understanding that states have a defined role to play in how their Medicaid program operates, and there is nothing like that in the way the 340B program operates. Thank you, Your Honors.
Thank you, counsel. Even though we're going to see most of you again, we're going to come down and greet counsel because we won't see one of you. And then we'll proceed right into our next case. You may be seated.
I'm a little slow.
Oh, boy. Mr. David, we are happy to hear from you, but understand that you are walking into a conversation that is halfway over. We're happy to hear from you.
Thank you, Your Honor. May it please the court, Caleb David on behalf of the state defendants. The West Virginia legislature exercised its historic police powers to fill a gap in the 340B statute. It passed a law that prohibits manufacturers from limiting the use of contract pharmacies and from conditioning delivery on providing patient claims data. The district court in West Virginia got it wrong. It is the only court in the entire country at the district court level or at the Court of Appeals level that has found one of these delivery statutes to be preempted. And it got it wrong when it found that these provisions were an obstacle to 340B, especially in light of the heavy burden that's required to issue a preliminary injunction. And this court should reverse. And I want to be clear about the two questions that are before this court. It was error to find that West Virginia's prohibition on conditioning delivery of 340B drugs on providing claims data was an obstacle to 340B's enforcement. And it was also error to find that the law's enforcement mechanisms intruded on the federal government's role simply because state officials might need to interpret federal law. 340B is a pricing statute. It has three key.
Can I just ask, do you agree when we sort of look at this, that you began by saying a gap in the 340B program? Is the central sort of divide here whether the silence is itself an indicator, a preservation of a right to make an offer, or whether it is a gap? I mean, is your argument sort of turn on reading the silence with respect to contract pharmacies? I know I'm being imprecise, but bear with me. As a gap that is open to be filled, or whether that silence is a preservation of a right for the manufacturer to make an offer? Is that like the distinction such that if it spoke to this question through silence or otherwise, you'd agree we'd have a problem, but you think because it's silent and that there's a gap that it's allowed to be filled? Is that trying to get to the nub of it, what you think the right way to think about it is?
So I think that two ways to think about this. First, you can think about it as this silence leaves a space open for states to regulate. And that's what Santa Fe said. And I think that's also what Novartis said. Now, if we take the Novartis point and we look at that as whether that's preserving some rights that the manufacturers have, we also have to look at the context of the rights that states had, because absent the 340B program, states have the ability to regulate manufacturers and the shipment of drugs. That's undisputed. It's a health and safety regulation.
But that's like a level of generality problem, right? So there's no doubt that you can like regulate pharmacies, right? But the question is, can you regulate the 340B offers, right? So you might be able to regulate whether they can sell cocaine or marijuana as medical, for medical purposes. Like that's traditionally within your realm. But it's a little hard to say you have a traditional role in regulating 340B offers, because it's like a federal program itself. I agree with you. If there's a gap, then that you could fill that gap, at least in theory. But if the silence means something, then it seems, in other words, it means preservation, then it seems like you've got a harder road to hoe.
Your Honor, the argument that this is a part of the offer, that's the argument that lost in both Santa Fe and Novartis. In those cases, the manufacturers stood before the courts and said that offer and delivery are separate concepts. That was the argument that they made, and they won. And now they're standing here and saying, no, delivery is a part of the offer. And then I heard them also say—
Yeah, but that seems like, maybe I'm not understanding that. Like, they're saying, or at least the court has said in the DC Circuit, that the offer includes something other than price, right? And one of the things it can include is the number of people that it has to, treat as the agent of the covered entity. That's like a preserved right under the spending clause legislation.
I don't think that it went that far, and it certainly didn't go far enough to say that preservation means that in silence we are going to preempt any state law that touches on this. That's simply not a preemption doctrine that exists in any court anywhere. Silence is not a preemptive condition in any statute, and they haven't pointed to a single one that does preempt, where Congress has preempted in silence. They don't do that, and particularly they can't do that in this field, because this is the field of pharmacy. This is the field of health and safety. These are traditional areas of state regulation. regulation, and Congress has to express a clear manifest purpose to preempt in those spaces. No one argues that Congress expresses that purpose. The argument is that Congress somehow implied it through their silence, but Congress, again, has never done that in silence. They haven't pointed to any specific doctrine where Congress can preempt in silence.
Can you point me, maybe this is another way of asking it, is like, can you point me to any other example where states have expanded a federal program? Like have said, this federal program that exists, it needs to be different. We're gonna redesign the federal program in West Virginia, and we'll leave the federal program elsewhere. The examples I can think of are all like Medicaid, where the federal statute says that it's cooperative federalism, right? The statutes identify the state's role. What I can't find is an example where states have rewritten federal programs within their borders and imposed additional requirements or obligations on those federal programs just within their borders. Is there an example of that I ought to look at?
So as a preface, of course, we disagree that this changes the federal program at all, but to answer.
Well, but you do agree that it means for a 340B program, they cannot make the offer they want to make. That they can make in other states that don't have your law. I mean, it changes the program in the sense that, like, in West Virginia, they have to do something different than they do in South Dakota. I don't know if South Dakota has one of these laws, but bear with me, right?
Right. We agree with the manufacturers as their position was in the Santa Fe and Novartis case and what those courts held, that these are separate concepts, the delivery and the offer, because the offer is in statute. And the courts in both of those cases specifically said that it's silent, completely silent as to delivery. So it's something that's completely a separate concept. So what they are saying is that we have our own contract pharmacy policies, and there's over 700 manufacturers in the program. So they all have, well, not all of them, but dozens and dozens of them have their own policies that they change without any federal oversight.
I guess I don't understand this distinction. They're saying, we want to make an offer that says, this is an offer to sell you 340B drugs at the price required in full compliance with the 340B program, but that offer is limited to shipping them to a single contract pharmacy, right? That's the offer they want to make, and you agree West Virginia prohibits them from making that offer.
I agree that West Virginia would prohibit them from not shipping to a contract pharmacy.
No, but West Virginia, like, prohibits them from making the offer, doesn't it? Well, tell me why you think that's different. Maybe that's where I'm not understanding you.
Sure, and why I think that's different is that the federal government was trying to say that this was part of the offer and therefore they could regulate it. That's what the federal government was trying to do in Santa Fe and Novartis. They issued enforcement letters against the manufacturers and said, you are violating the terms of 340B program by putting these conditions on your offers. And the court said, well, those are different concepts because that was the
Okay, but
winning
why
argument.
when your statute says that we prohibit the acquisition under these circumstances, why is that not prohibiting them from making this 340B offer? I guess I don't understand this.
All that the statute is saying is that you're going to sell those drugs to a contract pharmacy and you can't.
You don't want to say that.
I'm sorry.
You do not want to say that.
I'm sorry, I misspoke.
You actually are totally right, but that is the opposite of your position.
No, you're going to sell these to a covered entity, and the only thing that's changing is the delivery address. That's literally the only thing that is changing, because you could sell those drugs.
No, it's on a totally different set of terms, right? Like, it's not that the delivery is the only thing that's changing, right? It's like whether you get to use 1,000 agents or whether you have to use a single agent, right? That doesn't matter whether the addresses are different or the same, right? Like, the question is just, do you get to use a bunch of agents, which make it hard for us to tell about diversion, or do you have to use a single agent, right? But that's a term, that's a term of the offer, right? Not like merely like a shipping address.
The reason that it is just a shipping address is because these covered entities can buy all of the quantity of drugs that they want, and they can ship them to contract pharmacies. The problem is that delays the care and actually getting the drugs to the patients. So the covered entities could take on that burden and do this themselves. There's nothing in the statute that prohibits that at the federal level or at the state level. they could do that. But the purpose was to
Well,
provide.
Maybe, but then they would be responsible for the diversion, right? Because then there would be a debate about, are they sending them to the right places and the right people, right? But it may be that a covered entity can do that. The question is, like, is a manufacturer required to let them do it a different way?
They're always responsible for the diversion. That never changes. The covered entity is the one that is always responsible for diversion, not a contract pharmacy. So if there is diversion, and you had raised the hypothetical about shipping to other places, and there was a discussion about Johns Hopkins and shipping to all of those different locations, all of that can be resolved in the 340B ADR program. That's specifically what it's designed to do. And if Johns Hopkins is diverting drugs, particularly in this instance, if they say that, well, they're shipping massive quantities of drugs to Hawaii, that's reasonable cause to initiate the audit process, find out if those are 340B patients, because that's another thing that I think is getting lost, is that there's nothing that changes who can actually receive these drugs. It will always be a 340B patient. If they are outside of that, the covered entity is engaged in diversion, and the manufacturer can always go to HRSA to correct that. And the covered entity would either have to pay that back, well, they'd have to pay that back. The other option is that HRSA can kick them out of the program. So that's something that's handled exclusively in the 340B ADR process.
Can you respond to the argument, Can you respond to the argument that I think Mr. Perry began with it and Mr. Owen then brought back to it, that the ADR process includes this very type of claim?
And I think that that's an interesting position, because that was specifically what was not included in the process in the Sanofi case and Novartis case, because they were putting delivery conditions, they issued enforcement letters, and they said they didn't have that power. And now they're saying that they do have that power.
But the regulation was enacted after those, right? After those enforcement letters, right? And so I thought it was the covered entities that were saying, yes, we want ADR to be able to adjudicate these things. And so when we look at it now, I understand this different argument, but you agree that the current regs permit ADR to address those challenges?
I don't believe they do,
Okay,
because
why not?
Congress.
That's what I was trying to get at. I don't understand the rest about the other cases where it didn't exist, but why is that?
Because Congress still hasn't given that power. They haven't changed the statute and given that power, and that's specifically what Sanofi and Novartis found, was that Congress didn't give HRSA the power
Oh,
to
no, you might
regulate
lose.
this.
That's a different question, right? So like the ADR process permits this claim. You're going to lose because we know the federal law doesn't require the offer to extend to any contract pharmacy that you want, right? But the ADR process allows you to bring that claim.
I don't think it does, and I think that that's the big difference, is that they're talking about overcharging. That's something that's always been within the realm of HRSA and the 340B ADR process, because that's something that specifically deals with pricing. Nothing in the West Virginia law deals with pricing at all. It's simply two questions. Did you ship the drugs where the covered entity wanted you to ship them? And did you condition that shipping to whichever location on providing claims data? Those are the only two questions. None of that has to do with pricing. It doesn't have to do with how much is being charged. So that overcharging, they're reading into a definition now, something that they specifically said that HRSA didn't have the power to do 2 to 3 years ago in the Sanofi case. So it's a completely different argument that they're making now than what they made then, and they're now saying that, well, we're going to go back and make that same argument again whenever we have to go in front of HRSA. We're going to say, well, you don't have the power to actually deal with this. So they're just jumping after they win these arguments. We're adopting what they won in Sanofi and Novartis and saying that that is the rule here, and they want to change the rules.
Let me ask you about because you cited the other states, and you said the West Virginia, I think this is the only case where the district court has ruled against the states. But you do have that little clause in there regarding the condition, the data claims condition. And of course, the manufacturers are saying this is in direct conflict with the 340B statute. So I wanted to hear your response to that.
Yes, Your Honor. The 340B statute doesn't mention claims data at all. And what the manufacturers are really arguing here is that they should get the opportunity to conduct pre-audit audits, which is not something that's contemplated in the HHS guidance for the audit process or the ADR process. So all they have to show is a reasonable cause to believe that there's been diversion or duplicate discounts. And reasonable cause can be something.
Your
as-
argument's the same, so in other words, your argument's, they're silent about this too, and so the state can prohibit manufacturers from getting information that would allow them to bring an audit.
No, they don't
You're
need.
saying it's not preempted because there's silence here too, because the audit provision doesn't like quite extend down as far as you suggest.
I'm saying what Congress said and what HHS said. Congress doesn't say that they need claims data to initiate an audit. HHS doesn't say that they need claims data to initiate an audit. What they say is that it can be something as simple as the hypothetical that's been discussed. Large quantities of drugs being shipped to locations, big changes in the quantity. It can be patient complaints or complaints from other manufacturers about the activities of a covered entity.
So indirect ways are permissible, but direct ways of actually looking at the data, West Virginia can prohibit.
What West Virginia prohibits is doing it before what the audit process allows. So the audit process allows them to get that claims data. So they can put that in front of HRSA and say, we need claims data so that we can confirm that Johns Hopkins is diverting drugs to non-340B patients in Hawaii. West Virginia's law wouldn't stand in the way of that because it specifically says that it prohibits the getting that claims data unless HHS requires the claims data. So if they approve an audit plan.
Just say one more time. So what in the 340B program prohibits them from getting the claims data? What, you just said the 340B program prohibits them from getting the claims data pre-audit?
No.
What provision prohibits it?
Doesn't prohibit it. They're not entitled to it until the audit process. That's.
I thought, what was prohibited then? You just said they were prohibited from getting the data. What prohibits them?
West Virginia law prohibits them from getting the data before the audit. Nothing entitles them to get it before the audit. And once they have the audit, they can request that claims data in their audit plan. If it's approved by HRSA and HRSA says you're entitled to get this claims data, West Virginia's law doesn't stand in the way. And the problem that they have is they've never once cited to any time that an audit plan has been denied because they didn't have claims data beforehand. They simply do not have that. And I see that my time has expired, so unless there are any further questions, I will reserve the rest for rebuttal.
Thank you, counsel.
Thank you.
Different order this time. Mr. Perry?
Thank you, Your Honor. May it please the court, I want to address ASTRA enforcement, and I also want to address claims data, but if I might, I'd like to make a specific point, this time about page 53 of West Virginia's brief. And this, again, refers to what I discussed last time I was up, and that's section 4 of Novartis, where they said a one-contract pharmacy policy, it's much more limited than universal delivery, it was addressed in Novartis and Sanofi. A one-contract pharmacy policy is fine. Here's what the state says their statute's trying to do. So when a covered, this is a quote, so when a covered entity buys discounted drugs from a drug maker, the act prohibits the drug manufacturer from conditioning that sale on the entity's agreement not to contract with multiple pharmacies. Irreconcilable conflict, Your Honor. Now, if I might also just note, federal preemption, of course, turns on congressional intent, and that's what the Supreme Court was dealing with in ASTRA. What is Congress's intent in the 2010 amendments to 340B? That's section D of the statute and so forth. And as the court already noted in the last argument, Congress intended 340B would be administered and enforced on a uniform national basis without the enforcement burden spread among multiple decision makers. And the risk of conflicting adjudications would be substantial if you had courts or
Your colleague in the last argument, or this one, I don't remember which, says, yeah, but Astra is just price, right? That Astra is just about price. So it is not that Astra would not apply if there was a private cause of action about something other than price.
I don't think you can divide Astra just into price or something
Why,
like.
but why not?
Well, because this federal statute on which all of these considerations I'm mentioning come into play is not just about price. It's about price, it's about diversion to somebody other than a patient of the
All right,
340B
but
price.
what
drug.
about maybe a slightly better version of that argument, which says Astra is limited to those things that are express in the 340B program, right?
Right,
So
so-
price, diversion, right? The things that are expressly included, Astra would prohibit, but you could bring a private right of action on anything else you wanted to.
There are multiple things, including price and diversion. There's duplicate discounts, there's
No,
all.
but I'm asking a different question, right? Which is, could you bring a private right of action to enforce something, a state law, where the 340B program was silent under Astra?
You can't do something that interferes in the 340B program. Your
But that,
hypothetical.
but Astor was about, they were trying to sue as a third-party beneficiary to the contract,
Right.
right? And the Supreme Court said you can't do that. There's no private right of action. We can't have everybody claiming to be third-party, that's covered entities trying to be third-party beneficiaries. And the court said no. But the question that we're trying to get to now is, what if there's a state law that has nothing to do with being a third-party beneficiary? They're not trying to enforce the contract, the PPA, or anything. They're trying to enforce a different law. Why not?
If it's
Why
a
does
state.
Astra cover that?
If it's, let me just answer it two ways. First, if it's a state law of general applicability, the preemption principles would apply if there's either a conflict or Astra comes into play. The question I think that's being asked here is, what is the field? If this yields field preemption, if the Astra rationale, if it was a state law claim rather than a federal common law claim, it would have been decided probably based on field preemption. So what is the field here? I think that's the question you're asking. What is the scope of the field?
Yeah, the analysis would be the same, whether it's a private right of action as in Astra, or whether it's a state attorney general action in a preemption context. But the question, even though they are in slightly different contexts, one is a third-party right of action, the other is whether a state AG can enforce. But those seem to be the flip sides of the same
Well,
coin.
so here's what the field is. It includes what can the federal government do in regulating what's an appropriate offer under A1, right? And that is a question of what conditions. I think Your Honor repeatedly asked this over the last hour or so. What exactly are the conditions that are appropriate and what are not? That is within that field. That controls the extent of your
I'm
obligation.
sorry, say your field again. The field was what can the federal government not require?
It's tempting to say everything about 340B is within the field, but let me
Yes,
be
that seems
much
to
more
be your
precise,
argument.
because I'm not saying exactly that, right?
Okay.
So A1 is about what you're required to offer, right? And as you know, both Judge Katsas in Novartis and Judge Bibas in the Third Circuit case say, well, there are certain things that you can do in your offer and certain things that you perhaps don't need to do. But the question is, the federal government, when it regulates that offer, that ought to be part of the field. What are you actually obligated to do, right? And I'm not obligated to ship to more than one contract pharmacy. We know that from Novartis. That's part of this field that the rationale in Astra ought to cover. Also diversion, also duplicate discounts, but it certainly is, what am I obligated to provide the 340B price on? That is a pricing question, but it's also a delivery question. As we saw in the Novartis case, the court applied a very specific test. It's a bona fide offer, reasonable offer. If your offer under A1 is bona fide and reasonable according to the federal government, you can do that. The state says it's illegal. Very specific black and white problem, irreconcilable conflict. I'd like to be a little more specific about the conflict between the types of enforcement provisions in the federal and the state statute, if I might. So this is Section D. It came in 2010 amendments Congress promulgated. These amendments are addressed in Astra. The federal contract has an informal dispute resolution process. There are pricing discrepancies addressed through corrective actions. All of this is an iterative framework meant to ensure compliance. That's the purpose of what Congress did. It was settling problems that existed at the time. It was creating tools for the agency to resolve these issues, including the unique administrative dispute resolution process. That is not what the state's enforcement provisions do. They have a $50,000 per drug package penalty. They are attempting to compel conduct That's not required by federal law. These things, as the Supreme Court has told us in Gould and in Crosby, when you have competing enforcement mechanisms like this, conflict is imminent. These things cannot coexist. There has to be preemption. And the district court also talked about.
All right, I think we've got you. Thank you, counsel.
Thank you.
Ms. Ellsworth, I think you're now, get our next 7 minutes.
Thank you, Your Honor. I want to start where West Virginia started, which was to invoke its historic police power as a reason to allow this statute to exist. There is no history of the state of West Virginia regulating historically 340B drug sales or offers. There's none. This is not an exercise of historic police power. This is not a law of general applicability, and that argument should be put to the side. Second, I heard West Virginia
Well,
tell you.
When we say 340B drugs, like that means pharmaceuticals at a certain price, right? Certainly, there is a history of West Virginia regulating pharmaceuticals, how they can be delivered, pharmacies, pharmacists, how drugs get to patients, all of that, right? There is no
Absolutely.
history, maybe, of West Virginia regulating the price of a, particular federal program, and that's what makes it 340B. But it kind of glosses over a lot to say there's no history of it regulating 340B drugs. Sure they did. They regulated all the drugs that are covered by this program.
You are far more precise than I was in making the point that I intended to make. That is exactly right. It is, this statute gets at the price term for the 340B drugs that arrive at a contract pharmacy. There is no history of West Virginia regulating that price. And that's why Your Honor's examples of other things West Virginia might do that are issues of general applicability to pharmaceuticals. You have to have a license, you have to have refrigerated trucks, you have to have certain security if it's opioids. Those are things that there is a long history of states and the federal government working together, sometimes separately, sometimes together in those sorts of circumstances.
To make pharmaceuticals, easy for patients to get who need them, right? There's a pharmacy in your neighborhood you can go to.
That's right. And Your Honor,
That's West Virginia's interest.
West Virginia actually raises patient access, I think, 7 times in its brief. I didn't hear them talk about it a lot today, but Your Honor's question touches on it. And so I do want to be very clear that nothing about this statute changes patient access in any way. These drugs, whether they are priced at a commercial price or they are priced at a 340B price, every Novartis product is available in every CVS, every Walgreens, every neighborhood pharmacy throughout the state of West Virginia. So any customer who walks in the door with a prescription can walk out the door with the drug in their hand. This statute has nothing to do with that patient access. What I heard West Virginia say is that the problem is that the covered entities otherwise would have to acquire all the drugs themselves and then distribute it out to the pharmacies, and that would result in delay. That is wrong, and I want to make very clear that that is wrong. That would be diversion. Under the federal 340B program, the only person to whom the covered entity can give the drug is a patient of the covered entity itself. That is exactly why in 1996, HRSA came up with this one contract pharmacy policy, because covered entities that did not have their own in-house pharmacy had no way to take advantage of the program because they couldn't give them to a pharmacy down the street or across the street. So HRSA said you have to have one. Novartis recognizes that and says you can have one, but it is not the case that the delay is the reason for this statute.
Does the statute require you to have one? Or does the statute allow a manufacturer to say, we won't deliver to anyone except the covered entity?
So, Your Honor, I think there's a question about whether the statute would require one. The way HRSA has interpreted it is that in order for there to be a bona fide offer, there would have to be a way for the covered entity to accept it, and for the covered entity who doesn't have an in-house pharmacy to accept it, there would need to be a contract pharmacy, one, available to that covered entity to use. That's how the Novartis policy works as well. That's what the DC Circuit addressed in the Novartis decision there. Does that answer Your Honor's question? The next thing I wanted to mention is that, because I know this court takes the creation of a circuit split quite seriously, and there is an Eighth Circuit decision out there on preemption that goes the other way. I think that decision is wrong for 4 reasons, and I want to specify what they are. The first is where I started talking with you, Judge Rushing, is that McLean assumed that state regulation of the 340B program was a traditional area of state regulation. And I think that is plainly incorrect. There is no state anywhere in the country that has attempted to regulate 340B sales or delivery at any point until a couple of years ago. So that, I think, is incorrect. The second is that the Eighth Circuit I think got caught in a tangent about who maintains title to drugs in this replenishment model context, and it looked to a 1996 HRSA document that is from a different time period when I think the single contract pharmacy did actually maintain separate inventory of the commercially priced drug and the 340B priced drug, and so there was a sense that the covered entity could retain title. The replenishment model makes crystal clear that there is no retention of title by the covered entity. The patient of the covered entity has already walked out the door long before this retroactive accounting mechanism is being used after a third-party administrator has come in.
Could you include in an offer letter that we will not operate on a replenishment model? There seems to be a lot of, you guys are really concerned about the replenishment model, and maybe you should be, and all the algorithms and stuff. Could you contract around that?
I don't know that anyone
Federal law is
has,
silent.
I don't know that anyone has tried to contract around that, but that is what the one contract pharmacy, the claims data requirements that we do use are getting at the same concerns that the replenishment model raises. So whether there might be a different way to get at those concerns, I think is a topic for another case and another situation.
How do you get reasonable cause to audit when a covered entity only uses one pharmacy? Like, what's some examples of how you've gotten reasonable cause to audit in that situation?
So I think this goes to something, and my time is up. Is it okay if I answer your question? This goes to, I think, Judge Richardson's comments in the earlier case, which is that determining whether there is potentially diversion or duplicate discounting or someone is not a patient of the covered entity who's getting the drug is much simpler as a process when there is only one pharmacy that you are looking at.
But how do you do it? I'm just curious, because the big part of the argument here, the district court seemed concerned that claims data is the way to figure out if you are entitled to an audit. And I wanted to know, when you're not dealing with this problem of lots of different pharmacies, say it's just an in-house pharmacy or just one, how do you get reasonable cause?
I believe it is still the way, because what claims data gives you as a manufacturer is it identifies the patient.
How do you get that?
How do you get it? From the pharmacy.
Do you just ask?
From the pharmacy or the covered entity, yes. And to be clear.
Can you get it without claims data? Can you have reasonable cause to audit? Because your friend on the other side said claims data only comes in an audit.
So that is actually, I think, incorrect, but claims data is something that pharmacies regularly share with not just manufacturers, but anytime you're exercising insurance companies get claims data as well. It's a mechanism of just making sure that the person is actually who the person is, who the physician was who provided it. And the DC Circuit gives an example of you could have a physician who has a private practice and also works at a hospital or has admitting privileges at a hospital. So you might want to know, for example, was the prescription that was written for an encounter that occurred in the private practice, or was it related to an encounter in the hospital? That might factor into whether the person was a patient of the covered entity for purposes of the 340B program. This claims data is very basic data that pharmacies and covered entities regularly provide. They provide it to CMS for Medicare and Medicaid for the same sorts of reasons.
Do they provide it because there's a requirement in the offer letter requiring them to turn it over?
So it is part of the
Or for a
Novartis.
different reason? You mentioned insurance.
So I think they turn it over in general because it's part of a payment system for insurers, for the federal healthcare programs. Manufacturers, including Novartis, use it as part of their 340B program. It is one of the terms of the offer that Novartis makes to covered entities.
Is there a way to get it without having this contractual requirement? It sounds like
There
there's.
is not, Your
It's
Honor.
turned over to insurance, you mentioned.
There is not a way for a manufacturer to get it, other than asking the covered entity or the pharmacy to turn it over.
Question regarding the reasonable cost, because he says it's pretty simple. And I'm not sure if you're agreeing with that or not, but he says that you can basically say that there's a difference in the quantity of drugs, or it could be something as simple as someone making a complaint, and that is reasonable cause for the audit, and that you don't need the claims data.
So, Your Honor, I disagree that you don't need the claims data. And I think the DC Circuit talks about the importance of claims data in its decision, and when it said that a claims data policy was okay. As I understand West Virginia's argument, it's that a manufacturer might somehow stumble across another indicator of a need for an audit, but because there's suddenly a huge increase, for example, in the number of drugs sold. But that is not the only purpose that claims data serves. So just let me try and again make this very practical. Imagine that I got seen by a hospital in West Virginia when I was on vacation. It was a 340B hospital. I'm now home in Virginia. I go to my primary care doctor, I get a prescription for antibiotics, I fill it at the CVS at my home in Virginia. Does the 340B entity in West Virginia get to claim me as a patient because I once filled a prescription there? These are the sorts of questions that claims data help manufacturers determine, or was I doing something at the CVS down the street from me that was actually connected to my past hospital visit in West Virginia. Only claims data makes that kind of granular information available, which is what a manufacturer needs to have the required documentation to even conduct an audit. You don't get to just do an audit because you want to do an audit. You are required to have documentation of reasonable cause to do so, and claims data is how manufacturers get that. Thank you very much, Your Honors.
Happy to hear from you.
May it please the court, Matthew Owen again for AbbVie. I'd like to tick through a couple of points, the theme of which would be that we should focus on the text. Starting with Astra, there's been some discussion about what Astra covers, what the ADR process covers, and whether it involves just pricing or other kinds of disputes. I think this is the type of issue where the text of the Supreme Court's opinion, the regulation, and the relevant statute resolve this. So what Astra says at page 122 of the Supreme Court's opinion is that Congress created the ADR process as the proper remedy for, quote, overcharges. And it cited a provision of the 340B statute, which is 42 U.S.C. 256B. That's the statute. And then subsection D starts to talk about, quote, overcharges and then the remedies for them. Section D3 is the part of the statute that says the Secretary shall promulgate regulations to establish an administrative process for the resolution of claims by covered entities that they have been overcharged. That's the same word. And then the statute, the regulatory provision that we've discussed earlier, 42 CFR 10.21A1, when it says that that the kinds of claims the ADR tribunal is supposed to hear includes any claim that a manufacturer has limited 340B pricing. Well, what I didn't say earlier is that it does so by defining an overcharge claim to include that type of claim. So it is extremely clear from Astra itself that what the Supreme Court is saying is this isn't some implied preemption issue or a generalized inquiry into a field. There is a specific federal law, 42 U.S.C. 256B subsection D, and that statute confers jurisdiction on the ADR tribunal to hear certain kinds of claims and to promulgate regulations to establish those claims. The agency has now done that. That regulation postdates Novartis, Sanofi, McLean, all those decisions. But the regulation itself on its terms says that an overcharge claim covers any claim that a manufacturer has limited an ability to access 340B pricing, which is the only thing that West Virginia law really does, because, as I explained earlier, all of these restrictions live at the offer level. You can find
So the regulation is doing the preempting?
the regulation has a force. Well, it's not just the regulation; it's the statute that does. Regulations can have preemptive effect if they're authorized and have the force of law, of course. But this, my point is that what the regulation covers, and it does have preemptive effect while extant, is defined by statute. And when Astra said the ADR process covers pricing, which is with the previous discussion, what it really said is that it covers claims for overcharges. Those have been defined in the regulation to include claims of exactly the kind that West Virginia is trying to set up a system of adjudication in state court to work out. By way of example, I think Your Honor asked earlier, what if a manufacturer said, well, we'll sell you the 340B drugs if you agree to the no replenishment model? Well, that would be a limitation on 340B adjudication. Or 340B pricing access. I'm not aware of anybody trying it, but if they did, the only way to adjudicate whether that was legal would be to go to the ADR tribunal and say, this is a, quote, limitation on our ability to get 340B drugs, because we can't get the sale at all if we don't agree to this no replenishment example. And the Supreme Court says the ADR tribunal's jurisdiction is exclusive. You cannot have lawsuits in court that might interfere with the agency's ability to administer the program on a uniform basis. That is an example of a kind of claim that I assume would violate the West Virginia statute, because it would be a refusal to sell, or a denial of the acquisition of our drug on some condition that West Virginia says is unlawful. And that seems to be the same thing. I did want to refer the court, there are a number of examples of our policies in the record, but one that's very clear is JA 277. And just so that it's really clear that these restrictions live at the offer level, it says covered entities will be offered and may purchase AbbVie medicine at the 340B price, provided it is shipped to the covered entity location. A proviso clause in a contractual offer means you will be offered this drug at this price in unlimited quantities, provided that it will be delivered at one pharmacy. That means if they don't agree to that, there's no sale at the 340B price.
Could they limit it to only shipping to the covered entity itself?
I agree with my friend on the other side. The question, it's not an issue here, but there'd be a really serious question whether you could do that, because as Section 4 of the Novartis opinion kind of has a good phrase for this, which is it a bona fide offer? And if the covered entity couldn't accept it, and I suspect the ADR tribunal might say, well, that's not a real offer because there was no way for that entity to accept it, which is more or less what the agency said in 1996, which is where all this comes from. In other words, the manufacturer policies that we're talking about here basically reflect the way this program worked for most of its life, because in 1996, the agency said this is how it's got to be throughout the program. The only other thing I wanted to make sure I said is the patient access point is completely clear in the record as well. That is, if you were to look at Joint Appendix 486, you would see a GAO report making clear that 340B pricing limitations don't affect access to patients. And at page 438 to 39, you'd see that about 1.4% of the time do patients participate in any way in the savings. And from our perspective, that relates to a lot of things, but one of them is our takings claim, because we're talking about the transfer of our property to someone else so they can profit from it instead of us. And to the extent that anybody here on the other side thinks that that's a taking for public use within the meaning of Kelo, all I would say is the record's pretty clear that money doesn't go to the public and it doesn't go to any integrated economic development plan that the court, even in the high watermark of Kelo, said would still be a necessary requirement. Thank you, Your Honor.
Mr. David, happy to hear from you.
Thank you, Your Honor. And I want to start back at the field. This is a field that is traditionally regulated by the states, and this court in the Just Puppies versus Brown case specifically talked about when Congress intrudes into a state-regulated field and they don't occupy the entire field.
This is just like a level of generality problem. Like, you want to say, oh, no, let's just pop it up 2 levels of generality, and this is about like health and safety, right? And they're saying, no, like the field is defined by what you've like tried to attack. And so if you had a general law, maybe that's the right field to think about, but you have a law that's focused just on 340B offers. And so like, the question is like, does the state typically involve itself in those types of questions, right? And the answer is, doesn't seem like there's a traditional historical basis, given that the right level of generality is the sort of 340B offers.
Regardless of the level of generality, this is still a state-regulated field. Whether it's health and safety, whether it's pharmacy, whether it's just drugs, whether it's delivery
Okay, but so
of
what you've
drugs.
just done is said, at a high enough level of generality, I can pick different words, but all of those are way up here in a level of generality, right? None of those are in the field that we're really talking about. Nobody is arguing that the 340B program preempts the field of drugs, right? Like, no, like that's a crazy argument, right? Nobody thinks the field that it preempts is all of pharmacy, such that the state of West Virginia cannot license a pharmacist, right? Like, that's like a laughable answer, right? The question is, does it preempt the field of 340B offers, right? And once you appropriately define the level of generality, this history doesn't seem to get you very far.
Again, that's the position that lost in both Santa Fe and Novartis.
Okay,
that this is-
I'm bound by neither of them, right? All I'm trying to do is figure out what the right answer is.
Right, and what I'm saying is that the manufacturers were correct in that the offer and delivery are separate concepts, and that Santa Fe and Novartis are both correct on that point. And the 340B only regulates pricing, and it doesn't touch delivery, and that leaves that open for the states to regulate. And I want to get through a couple of other points. Another way to look at this is actually to look at the pharmaceutical pricing agreement. It's at JA 272, and it says disputes arising under a contract between a manufacturer and a covered entity should be resolved according to the terms of that contract. Actions taken by the parties in such disputes are not grounds for termination of the agreement with the
Can
secretary.
you give me any examples after Astra where there was a state law contract claim between a covered entity and a manufacturer? Like, are there any such state law actions?
Well, there are.
I mean, just do you know of any example of, because I would think Astra sort of closes the door to that. And so what I'm curious is, are there examples of that like they showed up and they brought state law claims, like private rights of action, about, you know, the delivery or offer or contract between the manufacturer and the covered entity?
I'm not aware of any between a covered entity and a manufacturer where the covered entity has specifically brought something that's related to delivery outside of complaints that have happened in states that have passed these particular laws.
Right, but what I'm talking about is in the context, I mean, what you've just said is like, oh, no, just let them go bring their private right of action. But Astra seems to tell us, like, that doesn't exist. And the fact that nobody's bringing these state law contract claims suggests that other people understand Astra that way too.
And I don't think that that's the way that we are to understand Astra. So first, Astra wasn't a preemption case. It had nothing to do with preemption. It didn't involve a state, it didn't involve a state statute, and it also didn't involve delivery. It was about whether they were being charged more than the price that they were obligated to sell the drug at. That's clearly something that's covered by 340B. That's clearly something for the ADR process. There's no dispute on that. And so they weren't able to bring an action outside of what 340B says you are allowed to do for pricing. And so this is a completely different issue. And now that these states have passed these laws about delivery, they've been upheld by every court outside of West Virginia, those claims are being brought. They are being brought through the state's enforcement actions.
But not private rights of action, right? Those are state AG actions, right?
I don't know how every single one of those cases work, but I do think that some of them do permit private rights of action.
No. Thank you very much, Mr. David. We'll
Thank
come
you.
down and greet counsel, and we'll take a brief recess before we go to our final case.
This honorable court will take a brief recess.
Please be seated. The few of you that remain, we're happy to have you with us. We'll proceed to our fourth and final case, 24-1861, Figueroa versus Butterball. Mr. Hernandez. Oh, Miss Hernandez, my apologies. I should have picked up on that. We're happy to hear from you.
Thank you. May it please the court, Gilda Hernandez on behalf of the plaintiff appellant, Osvaldo Figueroa. This court should reverse the improper dismissal of Figueroa's payday claim and the erroneous grant of summary judgment in favor of Butterball. As to whether Figueroa's payday claims are exempted by the plain language of section 95-25.14 presents a matter of first impression. Simply put, the answer is no. Now, while the FLSA establishes the floor regarding an employer's statutory obligations, the Savings Clause allows the states to enact more generous protections, provided that an employer comply with the more stringent of the two. And since the purpose of the North Carolina Wage and Hour Act is to promote the general welfare of North Carolinians, and given the plain language of the exemption statute, the legislature's intent was to ensure recovery of all earned and accrued promised wages, irrespective of the Fair Labor Standards Act. Similarly, while North Carolina looks to the FLSA as a guide, the state statutes control where there are intentional differences. Unlike the FLSA, the Wage and Hour Act's notice requirement mandates that employers advise their employees at the time of hiring of the time, place, and manner of promised wages.
But doesn't the offer letter that he signed do just that?
Thank you so much, Honorable Judge Benjamin. The reality is that at the time of the pleading stage, this particular purported offer letter was not at issue. The district court was only solely looking at the allegations in the complaint and nothing more. So at that time, this purported offer letter was not really the issue before the court.
But I believe like now your client says that the offer letter was false, or maybe, I don't know if but does he have a different offer letter?
That's a very good question. So our client, Mr. Figueroa, unequivocally did not authenticate that offer letter. He disputed the offer letter, and at the time of his testimony, he repeatedly indicated that offer letter was not the one that he had seen or that he had signed. So it was not a matter of recognition of the purported offer letter, as the district court had suggested, and more significantly, what was
Can you just do that? Can I just say, if I got really bad evidence against me, can I just say, I conclusory claim that is false? I got no real explanation, I got nothing else, that I can just say, that letter is false, it must be made up. Is that sufficient to survive summary judgment, assuming that this was the sole issue? Probably not true, but assume that there was a single issue summary judgment. The question is there a dispute of fact? And there's documentary evidence on one side and testimony that supports it, and then there's an individual who just says, I have no explanation, but I just refuse to authenticate, or I believe that document is false. Is that sufficient to avoid summary judgment?
I think, Your Honor, the important thing is that the overarching issue relates to the Wage and Hour Act notice requirements, which mandate that communication, because where there are very specific ambiguities of conflicting information, that in and of itself should be a basis to deny the dismissal, the motion to dismiss by Butterball relating to whether or not piece rate was at issue, because that's the whole post of the
your answer is
problem.
no, but here it's different because of other information?
Well, because we have more stringent payday requirements versus the FLSA, and
So
as
he
I
can just
mentioned-
make a conclusory denial. That ain't true, and that's sufficient in your view?
Well, again, it's a little bit more complicated in light of the fact, Your Honor, that there were also purported offer letters to other turkey loaders that did indicate hourly pay and yet their pay stubs looked exactly like Figueroa's. So basically, his suggestion, his refusal or dispute of the purported offer letter was
So
exactly
what are the
consistent.
letters, what's the record where the letters purported hourly payment?
Absolutely, Your Honor. Those, that's Joint Appendix 2841-2853. Those purported offer letters that demonstrate hourly pay were for Rayner, Evans, Cleveland, and Adams. And again, those individuals, despite those purported offer letters showing hourly pay, their pay stubs looked exactly like Figueroa's.
So they may not have received notice, right? I understand maybe your argument, if they were there, they would not receive notice, but why does that help your client?
Because it goes to the question of ambiguity, and because, again, the Wage and Hour Act is more stringent than federal, that the ambiguity issue is one that would have been caused to simply deny the motion to dismiss, allow the parties to proceed to discovery, to basically, get more information as to what was the nature of this purported offer letter and whether or not it was in fact presented to Figueroa. Because again, he unequivocally stated that that was not the offer letter that he had seen. In fact, he was also.
Where in the record would I find his unequivocal statement?
That would be.
I just want to make sure I'm looking at the best thing you want me to look at.
Absolutely, Your Honor, and I appreciate the question. That would be Joint Appendix 1444-1445.
Okay, thank you.
Absolutely. But what we have here
Now,
is.
just to clarify, that was at his deposition, right?
Correct.
But you seem to be making a different argument right now about the motion to dismiss. You're suggesting you brought a North Carolina Wage and Hour Act claim about lack of notice because he didn't get an offer letter under North Carolina law? Is that what you're saying? I missed that in your previous arguments.
Absolutely. So, again, because the Wage and Hour Act has more stringent requirements than the FLSA, employers are mandated to advise their employees at the time of hiring of the time, place, and manner of those promised wages and comply with those promised wages. Because
Yeah, I thought
again, any
in front of the
ambiguities.
district court, you had an argument for overtime, and the district court said, North Carolina law exempts that because that's an FLSA issue.
Well-
And then the court addressed the straight time argument about, he said he was promised by his pay stubs an hourly rate, and the district court took that head on and looked at the pay stubs, right?
That is
And-
correct.
And then resolved that. So those were the two issues under the Wage and Hour Act.
Well, it's a little broader under the Wage and Hour Act because certainly Section 95-25.14 exempts employers that are subject to the FLSA from the bare minimum statutory obligations found under the North Carolina Wage and Hour Act, which is minimum wage, overtime, and record-keeping provisions. But Section 14 says absolutely nothing about the payday statute, which is 95-25.6, which allows a recovery of promised wages, and it says all promised wages. It doesn't provide for any exceptions with respect to a certain type of promised wage, and that's the issue we have here. Figueroa sought a claim under the payday provision for promised hourly pay, promised straight time, promised premium or
Let me ask you
overtime.
about that, because in his, I think this is the first two complaints. I think he acknowledges that he was paid under this piece rate compensation. And then he comes back and says, no, I was supposed to be paid hourly. And so we have the first two complaints. I understand you said that he disputes the offer letter, but he doesn't have another offer letter. And then he has the actual pay stub that shows the piece rate compensation that he, I think, accepted for years. And so I'm just curious as to, I'm a little confused as to what argument he's trying to make here, because he's made different arguments or allegations in his previous complaints. And as to this piece rate, and now he's saying, well, I'm subject to this because I'm supposed to be I'm supposed to have this hourly rate, although there's nothing that's really in the record that supports that other than what he says.
And that's a fair question, Your Honor. I can tell you that quite the contrary. The pay stubs actually show an hourly rate. They do not show a piece rate consistent with the CFR 778.318. They do not show a number of loads that any employee.
Is that like your argument sort of turns on that? So if hypothetically, except for a minute, that I think that's just wrong, hypothetically, does that resolve the case? Are we sort of done at that point? If the pay stubs show a piece rate system, then do you agree in that instance we're done?
No, we are not done because
So what would be left in that hypothetical world?
Figueroa was obviously not exclusively relying on the pay stubs, and that was one of the issues why the district court got this wrong, because the district court essentially considered extrinsic evidence that was not offered exclusively to support the payday claim. It was not offered or referenced in the complaints as for the purpose of truthfulness as it relates to those pay stubs. It was only one mere example, and yet, going to Judge Benjamin's point about the initial complaints, the court treated those initial complaints, the original and the first amended complaint, as though they were conclusive evidence as opposed to rebuttable. The appropriate thing would have been to simply allow the information to come in as admissible and then allowing Figueroa to provide additional evidence that would rebut the earlier testimony, and that's not what happened here. He simply took that and ran with it, and at every turn was looking to essentially, deny or dismiss
you agree
the North Carolina claim.
on the-
Sorry.
So you really just arguing the North Carolina cases. You agree on the FLSA cases that the district court properly considered that inconsistency in determining that there was summary judgment was appropriate. Your argument that you're making, at least now, is just about the North Carolina Act.
Yes, certainly because the Wage and Hour Act provides for different elements and more generous remedies, that the North Carolina Wage and Hour Act is more stringent. So the analysis should start there, not to mention the fact that
Can I then
we have-
ask,
Sorry.
what, in the gap that we have here between the North Carolina Act's dismissal and the discovery that was done on the FLSA, were you limited in your discovery in some way? I couldn't find in the record where your discovery was limited such that there would have been information about the North Carolina Act that would have come out that you weren't able to get. Did the court limit you in some way that you think is material to the North Carolina Act claims for discovery purposes? Or was all the discovery effectively the same for both of these issues?
Thank you, Your Honor. The information, what I would say was, well, obviously, at the pleading stage, he dismissed the North Carolina claim. We did find additional supporting information to corroborate the payday claim, but it wasn't like we were able to do anything. Despite multiple motions for reconsideration, the court still refused to reconsider the dismissal of the North Carolina claims. But if we were to continue to, for example, if this court were to reverse and remand, we would move forward with, class-wide discovery and then filing a motion for Rule 23 certification and trying to learn how many other people from the.
Can I just ask why we would do? Actually, your time's up. I'll let you come back up on rebuttal. How about that?
Thank you very much, Your Honor.
Mr. Anderson, we're happy to hear from you.
Thank you, Your Honor, and may it please the court, my name is Scott Anderson on behalf of the Appellee Butterball. This case is straightforward. The North Carolina Wage and Hour Act claim is exempted by North Carolina statute. That statute contains specific provisions that state that plaintiffs, or rather employees, should not bring overtime claims and should not bring minimum wage claims if their employment is covered by federal law. The introduction to all three pleadings that Mr. Figueroa filed in this case specify that this is an overtime and minimum wage case. This case falls within the exemption. As to the Fair Labor Standards Act, the trial court properly entered summary judgment because Mr. Figueroa admitted all of the key facts. As Judge Benjamin has already pointed out, he admitted in 2 pleadings that he was told that he would be paid under a piece rate system. In fact, in each of those pleadings, Mr. Figueroa specified the exact piece rate that he recalled being told. Mr. Figueroa also admitted during his deposition that he was, in fact, presented with an offer letter, and that he did, in fact, sign the offer letter that he was presented. And he also admitted in his deposition that the signature that is on the offer letter found within Butterball's employment records for Mr. Figueroa looks like his signature. Finally, Mr. Figueroa admitted that Butterball keeps accurate time records. Mr. Figueroa admitted that punching into work was the first thing he did each day, and punching out of work is the last thing he did each shift. He presented no reason to believe that any specific punch or Butterball's punch logs generally are under dispute. Because the court did not dismiss the FLSA claim on the pleadings, we proceeded with discovery, and specifically discovery into Mr. Figueroa's contention in his 3rd pleading that an individual by the name of Rocco, whose actual name is Russell Jones, told him he would be paid an hourly rate. Once we took that discovery, Butterball identified Mr. Figueroa's offer letter in Butterball's employment files. Russell Jones's deposition was taken. He testified that he told each loader-catcher employee that they would be paid based strictly on a load rate. Renee Arthur, the
What do you do to the offer letters that your colleague suggested, said some of them were given offer letters that were hourly?
Simply put, none of those individuals have taken an appeal in this case. Those offer letters are distinguishable on several grounds, including the fact that the closest in time offer letter is more than 4 years apart from when Mr. Figueroa's interview was. There are many more or equal number of offer letters contemporaneous with Mr. Figueroa's employment, a few before he was interviewed, a few after he was interviewed, that have the same language we have here. You will be paid a piece rate. This role is subject to overtime. It is that simple, and Mr. Figueroa signed that letter. We would also point the court to the fact that each of those offer letters contain rates, I believe, between $11 and about $13 per hour. Mr. Figueroa's claim is that in 2017, 4 to 5 years prior to those offer letters, he recalls something that stated $18 per hour. Now, there's once again a little bit of contradiction in Mr. Figueroa's testimony. At one point, he said he was promised an hourly rate of $10 per hour. At another, he says he was promised an hourly rate of $18 per hour. Where Mr. Figueroa's own testimony about what he believes he was offered contains multiple inconsistencies, we don't believe he's created a triable issue of fact.
What is the 18 number that's at the top of the pay stubs that says rate?
That is Mr. Figueroa's rate for holiday and vacation pay. He was, and I believe this is in his offer letter as well, eligible for holiday and vacation paid time off. Obviously, during those periods, he is not engaged in the loading or catching of turkeys, and so Butterball needs to substitute a rate and ensure that he is paid for that time off. And I also note that those rates are generally consistent where Mr. Figueroa was receiving a similar amount for those 40 hours of vacation time as he often received for his 40 hours of work when he had a fully active week.
Your interrogatories, I think, gave a different response for what that $18 rate is. The one you gave today is the one that makes more sense, and the one that the HR employee testified to. Does that create a conflict that should bother us, or?
No, and I believe Your Honor's referring to the training meetings that occurred approximately once per quarter, which were separate, non-productive time, and Mr. Figueroa and other individuals would receive pay at the separate hourly rate for that time when they were not engaged in the loading or catching of employees or engaged in activities that are directed loading and catching of turkeys, or engaged in activities that are directed towards the loading and catching of turkeys. The HR employee also testified that those are separate punches. If it was a 3-hour training meeting, the employee would punch in at the beginning of that meeting, punch out at the end of that meeting, and that's handled differently within Butterball's system. You'll also see that handled differently.
I thought the
on case
interrogatories in the district court relied on this, that they said that $18 rate is the they referenced the CFR, 29 CFR 778.111A rate, which is averaging, the loads over the week per the hours, and then figuring out what's your sort of like de facto weekly rate.
So
That's pretty clearly not what that rate number is, right?
with respect to the rate on the top of the pay stub, that is a fixed rate that for a period of time, Mr. Figueroa would receive that rate for activities that were not directed towards the loading and catching of turkeys. For overtime purposes, and I think this is what the interrogatories describe in significant detail, Butterball went through the process of calculating the implied hourly rate, or what the FLSA calls the regular rate of pay, which doesn't have to be an hourly rate. It can be a rate calculated based on what did the employee receive per hour once you back that out at the end of a week. And so in Mr. Figueroa's case, that means, and there are spreadsheets in the joint appendix showing all of
That would like
this.
change from week to week, right? Depending on how many loads you do, how
Correct.
long you work. We wouldn't expect that to be the same on every paycheck.
We would not expect that to be the same on every paycheck.
Can
To-
you address the argument regarding the, this non-principal activities and principal activities? I mean, I think I'll have a question for opposing counsel regarding this, but this, argument that he, I guess, cleaned the trucks and did all these different things prior to, and that he, under the FLSA, that he should be paid for that time. I think the case is integrity staffing, and then also that Mount Clemens case.
So, Judge Benjamin, that is a great question. This is a difference between Mr. Figueroa's testimony and the testimony of some of the other employees. Some employees testified that they engaged in work activities before punching in or after punching out. Butterball disputes that as to those employees and disputes that that was material time. Mr. Figueroa did not present any evidence along those lines. If he ever cleaned a van, that would have been after he had already punched in and was already receiving credit for being at work, receiving potential overtime calculations and the like for that work.
But I think I don't think the district court considered that evidence. I think the district court just said that it's sporadic. I mean, it did not really consider the pre-activities if they would apply as an integral part of, or indispensable part of, the work activity, as I guess describing those two cases. So I'm concerned as to, is there an error there because the district court did not consider those? But it seems like you're saying that he didn't make those allegations that everybody else did.
Mr. Figueroa did not make those allegations. We do not view those theories as being the subject of this appeal because none of the employees who actually did make allegations that they worked off the clock filed any appeal. And there's nothing in the issues presented on appeal that suggests that Mr. Figueroa himself engaged in off-the-clock time.
If they were, I take your response to be that they're not integral part if they're just done on a sporadic basis, right?
That is absolutely right, Judge Richardson. We believe that the trial court got it correct, that these were de minimis activities or activities done on a sporadic basis. And they do not suggest that employees were underpaid or that there is any systemic problem with Butterball's timekeeping.
Can you touch a little bit on why you think the other plaintiffs were required to appeal in order to present their claims to us, and why their claims are now resolved because they failed to appeal?
Of course, Your Honor. The case law regarding collective actions under the FLSA distinguishes between collective actions under the FLSA and class actions under Rule 23. Collective action mechanisms are essentially streamlined joinder processes. They are opportunities for individuals to affirmatively offer their interest to be participants in a case. They join as plaintiffs in the case. Each of the individuals who was a opt-in plaintiff below could have filed his own motion, could have filed his own appeal. They had the opportunity to file separate motions on any issue as a party litigant, and none of them filed an appeal in this case. And we note that the notice of appeal in this case, it is any language about Mr. Figueroa appealing on behalf of others is notably absent from the notice of
I
appeal
thought
that
the
Mr.
caption
Figueroa
said,
filed.
the caption has, you know, Figueroa on behalf of all others similarly situated. Now, the body of it doesn't have that.
I could be wrong, Your Honor. I don't believe that is the way it was captioned in the Fourth Circuit, and I don't believe that that is
But
the.
notice of appeal is not filed in the Fourth Circuit.
With respect to the caption used in the trial court, yes, Mr. Figueroa did use the same caption after judgment as Mr. Figueroa was using before judgment, which included language about and others similarly situated. However, we don't view a case where there are 9 plaintiffs and all 9 plaintiffs have their names listed in the caption. The filing by one of those plaintiffs, even if they're represented by the same counsel, would not necessarily be a filing by all of those plaintiffs. And so we believe the court should read the notice of appeal, and indeed many of the documents filed with this court, as indicating that there is one and only one appellant here, and that is the named plaintiff, Mr. Figueroa.
Well, the, you know, filings in this court and what have you, that could be a question of, you know, prejudice. Like, did you have notice you were defending claims of other plaintiffs? But the notice of appeal is actually like a jurisdictional requirement. So that's why I'm focused on what does the notice of appeal require? And you're saying the caption is not sufficient. He needs to list all the other plaintiffs in the body of the notice?
Correct, Your Honor. A notice of appeal would state, would identify who is taking an appeal and what orders they take an appeal from. And this notice specifies that there is only one person taking an appeal. I do want to address the policies and forms that my colleague brought up during opening argument. There are several forms that mention general hourly policies. Mr. Figueroa did not rely on any of those forms. None of the 3 complaints mentions any form involving Butterball on which Mr. Figueroa relied, except that the complaints, all 3 mention the pay stubs. We asked in interrogatories what policies, what forms, what writings did Mr. Figueroa rely upon. He didn't identify any of those forms. And so we don't believe that there is any claim based on an ambiguity in forms that Mr. Figueroa did not read or rely upon. The same is true of a job posting that Mr. Figueroa has pointed to. He states there was a job posting that identified an $18 hourly rate, but the record has shown no such job posting. I mentioned at the outset that Butterball keeps accurate time records. This is an issue raised in the appeal, but we don't believe, or we believe Mr. Figueroa's admissions fully address both Butterball's time records and Butterball's pay calculations, which used the work week that Mr. Figueroa admits was the applicable work week, and any confusion or discrepancy we have addressed by showing the specifics of Butterball's calculations.
Thank you, counsel.
Thank you, Your Honor.
Mr. Hernandez, we're happy to hear from you.
Thank you, Your Honors. There are several points that I would like to address in response to my colleagues' response, or oral argument. First and foremost, we have documents here that were conflicting with the information to suggest that somehow piece rate is what applied here. Again, and I think this goes to Judge Rushing's questions about the hourly rate. Even though Butterball's corporate HR individual admitted that the pay stub did contain an hourly rate, and they then later said that it was in connection with, consistent with 778.111, as Judge Rushing pointed out, that really goes to the question of, taking up all of the earnings for piece rate pay, dividing it by the hours worked to come up with the appropriate regular rate. And that rate should change or fluctuate every single work week depending on how many pieces or turkeys or loads are being gathered. And yet, that was the basis for the district court's, one of the reasons why the district court granted summary judgment, finding that that rate at the very top of the pay stub, even though it never changed except for an increase in hourly rate, was suggesting that it was a regular rate consistent with CFR 778.111. That's one point. The other point is that going back to section 95-25.14, the plain language there does not exempt any claims brought under the payday provision pursuant to section 95-25.6. There is also nothing in that section of the payday provision that limits what sort of claims can be brought, or what sort of different amounts can be proceeded with. The other issue relates to Anderson versus Mount Clemens. In response to a question by Judge Benjamin about the disconnect in terms of the hours, one of the issues that was also an erroneous finding of summary judgment, because there were genuine issues of material fact, go back to the question of the moving of hours from one week to the next. We had admissible information here from Butterball's people admitting and finding it troubling that they were moving hours from one week to the next, and that's contrary to the Supreme Court's ruling in Anderson versus Mount Clemens, because then there it establishes inaccurate pay records, and when that happens, the burden then shifts to the employees, and the employees should be able, by reasonable inference, demonstrate the extent and the amount of unpaid hours worked. And yet, the district court found that that they had a logical explanation for the moving of Sunday hours worked. It just doesn't make any sense. Also, the district court took the years, the summary of hours worked for 2017, for 2018, and said, well, all of these hours look pretty much the same to me, so I don't see any issue here. That was another erroneous finding, and again, just resolving the genuine issues of material fact in favor of Butterball. So that's another issue that we found.
On the issue of the pre-shift, your pre-shift, does Mr. Figueroa make allegations that, I know the opt-in plaintiffs made these allegations, but where does he make the allegations that he engaged in these pre-shift activities?
His allegations, Judge Benjamin, were that he was working hours and that he wasn't paid for all of his hours worked. And he disputed the pay stubs, which reflected a lot less than what he had been representing in his complaints, that he was working between 80 and 90 hours a week. And so in contrast to what my colleague was suggesting, that, those pre-shift and post-shift activities, which could actually encompass the number of hours that people are working, was saying, well, those are just de minimis. This court has very specifically found in Perez v. Mount Air Farms that pre-shift and post-shift activities, when they are integral and indispensable to the principal activities, are compensable time. So it has nothing, this court has actually rejected.
Actually, maybe just to answer Judge Benjamin's question, you don't have to, I guess you can not, but where is it that your client alleged that he had those types of pre-shift hours? What JA site do you want me to look at? Because when I read his statements, I didn't get it, but I want to be sure I look at the right place. So where is it that I would look to find your client's evidence, right, at summary judgment, that he did so?
Well, there are allegations in the complaints that he was working hours that he was not paid for. So
Okay, but that's not sufficient to survive summary judgment, right? Like, believe it or not, in this particular case, we have reason to doubt some of the allegations in the complaint because they're like totally inconsistent with one another. But like an allegation in the complaint isn't enough to survive summary judgment. The question is there anywhere, and the answer can be just no, I don't have anything. But like, is there anywhere that you want me to look to find where your client alleged the type of pre-shift hours that you've just sort of, pointed us to in citing our prior decision?
Certainly, and again, while there's not necessarily specific details that he was working pre-shift and post-shift, his allegations were that he was working hours that he was not paid for. I will say, however, Judge Richardson, that the opt-in plaintiffs, contrary to my colleagues suggesting that they have no stake or no dog in this fight, that is absolutely incorrect, because the named plaintiff was representing not just himself, but those similarly situated, and this was a representative action. The consent forms demonstrate that they are.
So your view there is that they didn't have to appeal.
That's correct.
Not that they did appeal, but that they didn't have to, because he was affected, that we should treat this like a class action, in other words.
It's a collective action, and certainly the district court did not grant the motion to decertify. So it still remains, to the extent that this court should reverse and remand, would stay as a collective action. That is correct. And so going back to your answer about where the information is, certainly the opt-in plaintiffs did provide information that they had worked pre-shift and post-shift activities. Thank you very much, Your Honors. I appreciate your attention to this matter.
Thank you, counsel. We'll come down and greet, and Madam Clerk, if you'll adjourn court for the day.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.